Law and crime having some issues, y'all.
There is someone on the way to stand in for Mr. Mondelli because he is still in a jury trial in DeKalb, which he and we thought would be over by now, but it's not. So he's somebody standing in and who's on the way, and obviously we're not going to do the pretrial hearing until both of them get here. But we can hopefully deal with Mr. Dark's request to withdraw. So that's my first like this part of my which apparently was earlier. Shocker, we have technological issues. Ms. Foster, do you know when GPDC is going to be able to join? Ms. Prescott, can you hear me?
I can.
Okay, thanks.
Yeah,
Yeah.
hey, I'm still trying to reach him to tell him to sign on. I sent him an email, but, you know.
All right, so, Mr. Dark, you're going to need to file an addition. All right, also, you represent information that you have made best efforts to alert the court of this condition that you set forth and the circumstances. But the court takes issue with that representation. The only thing you told me at the bench the last time we were in court that you had a court date in April that you needed to be at. And you told me the reason why, and I said that we would not have court those days, that I would excuse you to be to that court appearance. And that is all that you said to me. And you otherwise represented to me that once you got assistance, which the court has provided in means of funding, if necessary, for experts and investigators, that you would be ready for this trial. So while I am going to ultimately grant your motion of withdrawal, because I think the way it is presented, there is no way not to, it is not accurate what you put in.
Judge, did you want me to respond?
If you would like to.
Foremost, I apologize if the court takes that position. That is not my intention. It's a legitimate struggle for me.
And I'm not saying it's not. What I'm taking issue with is that you seem to suggest that you had already alerted the court that the struggles you purport to be having, you had already told the court about that, and that is not true at all.
And Judge, from my standpoint, it would be true from the standpoint of when we had the conference at the bench last court appearance. And I told the court that I did have this trial. and I
You told me you had a
specifically
custody case. People have
Right.
custody cases all the time.
Right.
That is not the same as saying what you are now saying.
I'm not sure what the difference is, Your Honor, but
Well, to say I am having a mental condition that makes me unfit to represent anybody is not the same as, hey, I'm going through a custody dispute. And I don't mean to be blasting your business, but you're the one who's
you are,
making
Judge,
that
and that's the
required.
difficulty. That was the difficulty in communicating the last time. It's not something that I want to blast. I don't want my family on the media and all of this stuff, but I don't have much of a choice. I don't.
And I'm
So I'm trying
sympathetic
my
to
best,
that.
and I'm sorry if it's not to your liking. I apologize.
What I'm trying to do is make sure that people who are on trial for murder have the representation that they need. And if this was actually going to be an issue, which it clearly is, this should have been brought to the court's attention well before now. You were told at the beginning of December that this case was going to trial in late February or early March. So this morning, at what is supposed to be the second pretrial conference, should not be the first time that you say to the court, you know what, I'm not in a state to be able to do this. Okay? So I'm gonna grant your motion to withdraw. And with regard to what that means for the state, I think it's going to have to mean that Mr. McMullen's case is severed from this, because I'm not gonna wait on the other two.
We didn't to be quite frank, the court, this will be, so we're gonna have 3 trials. I mean, it would, I think it would be more beneficial, and, in the interest of justice and judicial economy to push the trial up another month or 2.
Well, let me find out from GPDC what they can do in terms of representation, because Mr. McMullen, this is gonna be his 5th set of attorneys, which nobody should have to deal with. That's not his fault. If they can get somebody in there quickly and we can get them up to speed, that's one thing. But I mean, he sat unrepresented for over a year. He went through 3 different sets of attorneys in rapid succession because of, I think, issues with GPDC. He's had this attorney since July, but this attorney is not able to continue. So I don't know. I'm going to have to hear from them.
And yet, I don't want to make light of Mr. McMullen's situation as it relates to legal counsel, but I think it'd be relevant for the court to be made aware or be reminded that Mr. McMullen is serving a number of years in the Department of Corrections still. So he is waiting for his counsel, which I can promise you all members of the state would help whichever counsel is assigned navigate through the discovery as quickly as possible. In order to prevent a 3rd trial, in the sense that Mr. McMullen's case, whether he's severed or not, would be a part of the 2nd trial because it's part of the count 1 of the indictment.
Yes, I know the state is bound and determined to proceed with the RICO count. So I'm aware that that's going to be presented in each one of these cases. But I mean, they're otherwise, aside from that, he's facing 1 charge. That's murder. That's a serious charge.
Agreed. But
And, whether he is already in custody for other issues or not is not really what I meant. I meant nobody should have to go to court and face trial on a murder charge without an attorney who's prepared to try the case.
100%. I guess my point was, and I mean this in all due respect, the state should be penalized for that as well, because we have limited resources,
I
limited
understand.
employees. A 3rd trial would not be something that would be beneficial to anyone, but I would say it would definitely not be something that would.
I've just got to find out what our options are.
Yes, Your Honor.
Mr. Dark, can you, I know one of the issues that you said you faced when you first were appointed to represent Mr. McMullen was that you didn't have discovery. Now, you apparently didn't take any steps to get the discovery from the state, but you have the discovery now, correct?
Yes, Your Honor, I have the link and I also have a 8 terabyte.
Okay, let me ask you this. Can you, because I do not know yet who will take over Mr. McMullen's representation, can you just get the entirety of your file and bring it to the court, and I will hold it. I will not look at it. I will hold it so that whomever is ultimately appointed, I can give that to them and they can have the benefit of what you've done thus far.
Your Honor, yes, I can
Okay.
bring the discovery and I can try to have it.
I mean, not just I mean, everything you've worked on,
Okay,
okay? I mean, your entire file.
okay.
All right, I appreciate that. Is that something you can do? When can you get that to us?
I'll have to look through the file to see, like, counsel impressions and notes and things like that.
Okay, I mean, you're welcome to put it in something sealed, but
Okay.
I mean, your attorney impressions and work product and what have you might be beneficial to Mr. McMullen's next attorney. I mean, yeah, I'd hate for he or she to have to start from square one if you've already gotten to square 25, you know?
Okay.
Okay. Does Mr. McMullen have any objection to that? No? Okay. All right, so can you get that to Chambers by like Wednesday of next week?
I can do that.
All right. If you will do an order, I will grant your motion to withdraw. And Mr. McMullen, I'll do my best to get other counsel lined up as soon as possible. But I mean, because you've had attorneys in the case and then out of the case, in the case and then out of the case, that our public defender system is great. Our conflict defender system is pretty good. Our conflict after you move past the second appointed attorney in a case is sometimes a challenge because of a lot of reasons, one of which is probably we don't pay them enough, but it's just challenging to get attorneys who are capable and willing to take on complicated cases. So I'll do what I can. Okay, so any word, Ms. Rosser, from GPDC?
Judge, Mr. Price is supposed to be logging on shortly.
Okay,
He has not yet, and Ms. Rosser is on her way down.
is what?
She's on her way down
Okay.
to 1C.
All right. All right, so we're just waiting for them. And then after I speak with them and get what is hopefully a timetable, we'll just recess until we have the other two attorneys. And then we may or may not, depending upon what they say about timing, go forward with the pretrial conference.
I think that's just messed up. So what we just saw was Demise McMullen's attorney withdrawing from his case. This is Demise's third public defender that has, basically dropped off. Right now, Demise only faces the underneath that. Right now, Demise only faces the RICO charge in combination with the murder. So they got him for the murder or the unaliving of Donovan Thomas. The thing about that is that they don't have any evidence to support that Demise did anything. He's not on any video cameras or anything. He is just making calls around the time of the incident, and they have his cell phone data. I honestly think that it's not enough to go to a jury and have them reasonably say that he's guilty of that unaliving. And so I really think that at least that charge would get thrown out or dismissed with a directed verdict. That's my personal opinion. The RICO charge, it's been so long since I've looked at the indictment. I can't necessarily tell you. That's Demise right there, y'all. That's Demise McMullen. The one that they kept putting on the camera was Demekion Garlington. But I think that they need to let it go. They don't need him. They don't need him. Miles is free. It's backwards. Sonya, Miles ain't in there. Miles already took a plea. He already took a plea. So just recapping for anybody who just jumped in here. So Demise McMullen's attorney has withdrawn for personal reasons. I am not going to be the person who repeats what the reason is, because he clearly does not want it told to the world. And Whitaker definitely violated him by saying what the issue was after he had already approached her during the last hearing, basically trying to tell her, what was going on. She felt that he kind of misrepresented to the court. And so she kind of had it out for him. I'm not gonna say had it out for him, but she definitely had words for him. They were pretty harsh. And he did stand up for himself, and that voice got up there. And I'm proud of him for advocating for himself, because she was wrong as hell to do that, in my opinion. She should not have done that. Apart from that, Demise has to get she wants to have him severed. The state doesn't want to get him severed because his case by himself, I think he's walking. He is currently serving time. And so the state, basically their argument was that, push the court date back. Let's push the start of the trial back. And, he's already serving time, so it's not like it's going to be anything different. But I think that was very rude of Mr. Abate himself, because I feel like it's a violation of due process. They need to just let it go. They are headstrong on getting somebody out of this group convicted for the unaliving of Donovan Thomas. And I just feel like Demise McMullen or any of these guys can be proven. I don't think that it can be proven beyond a reasonable doubt for any of these guys that they did that. Like, I just can't see it. So super unfortunate. We're on recess or break right now. I guess they're gonna come back. I didn't see Mr. Eppinger's attorney there. We saw Mr. Eppinger, so I'm expecting that we will come back to this. But in the meantime, and in between time, if you have not done so already, hit the like button, like the live. I don't know how many people we got watching from YouTube. Let's see. We got about 39 people watching from YouTube and 29 likes. So I need y'all to hit that like button. Get our likes up. Keep us in the algorithm. We also have a super chat goal today, y'all. So I put the super chat goal out there. We're just going to celebrate with the gang. It's going to go for 3 hours. Our goal is 10. And you can submit for $2. Like, that's just what it is. So if you want to help us reach our goal, just go on out there and send a super chat. All right. In the meantime and in between time, we are going to be watching. Ooh, wait a minute. We got audio. Yak does not have a hearing today. His hearing was canceled. The state withdrew their motion for revocation. His next hearing is going to be on this. I'm sorry, February 26th. So hashtag free. Everybody drop a free yak in the comments. Taylor Gang, let me tell y'all what I did for y'all. Let me make myself bigger. So yeah. Taylor Gang, let me tell you what I did for y'all. I created special emojis for the members. Special emojis for the members. So if you are a Taylor Gang member, you can go to the emojis. And if you can right now, go ahead and drop a not guilty. Drop a not guilty for Yak. We got a not guilty emoji out there. Drop a not guilty emoji for Yak. Yeah, I'm trying. You know, I've been peeping how this works. You know, I'm still figuring this whole YouTube thing out. But I got y'all some special emojis. So go ahead and drop that not guilty. That not guilty for Yak. All right. Because Yak was not guilty and they need to let him go. They need to let him go. So hopefully I believe that the bond here, he should be able to get out on bond for the charges that he has remaining. But we shall see what happens. We shall see what happens. So I will keep for Yak. I will keep an eye out on the feed for Judge Whitaker's courtroom. Wait a minute. Y'all, we can hear y'all. Thank you, Yaya, for your membership, Kay. We appreciate you. Make sure you take advantage of those new emojis that are especially for all of our members. So you got to be a member to get access to the emojis. Let's just run through them so we can show the people what we got. So we got a not guilty, which we just threw out there for Yak. We also have a gavel. So anytime we see a judge laying down the law, I want y'all to throw the gavel out there. Somebody drop a gavel real quick so everybody can see what it looks like. Okay, so I don't know what line sign is. Oh, okay. I don't know what line crime is doing. So I'm gonna mute them. Sorry about that, y'all. I was kind of confused on what was going on. So we have a gap. Oh, wait a minute. Thank you, Kim. Kim, they threw him out there. Kim been threw him out there. So we've got a gavel. We've got free the jury. All right. Anytime that we feel like it's a waste of time or that the prosecution needs to let it go, the defense needs to let it go, I need y'all to drop the free the jury emoji in the chat. Okay. Let me see what else. What other ones we got? All right, we got justice. Anytime we feel like a decision has been made that has been made correctly, we're gonna drop that justice. Or you can throw the book at them. Whatever you want to do. We got a guilty and we also have a not guilty. So if you are a member of the Taylor Umbridge community and you have a request for, let's say, another type of emoji, just go into our members chat, our members only chat, and just let me know what's up. Okay, because I will get us an emoji created. I'm also working on figuring out how to do special thanks to our people. So just more, the channel is going to grow more and more as I get more comfortable, as I learn more about YouTube. So I'm just happy that you guys are here to, watch with me. So again, as I said, we're going to actually go over to Ace.Rocky because I did not watch After Lunch yesterday. There was a law school forum and it was basically like a virtual law school event where you can go to different schools' Zooms and ask questions and hear more about the schools themselves. And so I spent my afternoon doing that instead of watching the trial. So I missed just about everything that happened. So we're going to go and just jump into that. And whenever Whitaker comes back, we'll handle it.
An attorney is not relevant. It only applies meaning to the answer. There was no answer to the question. This is minutia. This doesn't amount to anything. I don't want to take any more time about this. The jury is waiting outside. Jury can come in. I need response. No response. That's necessary. Yeah, no.
Can you see it on the screen? Yes. Oh, let me
turn on your little screen on your computer. So you don't have to constantly turn on. Good. Yes. All right. Is this the presentation that you created for this case?
It is.
I'm going to go forward to slide number 2. Can you tell the jurors what we see on this slide?
Sure. Well, in the course of this examination, there's a few different areas of basics that will help the jury understand the fundamentals of what we're talking about, and then actually the conclusions at the end of the examination. These topics are separated on this slide. They include firearm identification, cartridge components, pistol discharge, type and caliber determination, evidence features, ghost guns, and my ultimate findings.
Okay. We go forward to start with the first topic on your list, which was firearm identification. If you would tell the jurors what generally firearm identification is.
Yes, so within forensic science, there is a large discipline called tool mark identification. So this is simply the practice of looking at marks that are caused when a harder object impacts a softer object. Sometimes those marks can actually give us information about the objects involved. Firearm identification, what most people would call ballistic comparison, is really a subset of tool mark comparison, in which that tool is actually a firearm.
You talked about different types of tool marks. Can you discuss that just a little bit more for the jury? What it is that they're looking at when you do a tool mark identification examination?
Yes, well, the tool is simply the harder of the two objects in forcible contact. The reason we use that word is because this is often performed using hand tools like chisels or bolt cutters. If they're used in many different types of incidents, property crimes and such, they can leave marks on items that they've come into contact with. Those types of marks vary. There's two different general types. The first is an impression. An impression is straightforward contact between the harder and softer object under pressure. The striation includes that contact, but it also includes lateral motion. So essentially, an impression is a dent, and a striation is a microscopic scrape mark.
Okay. Can you talk to the jurors how this relates specifically to firearms?
Yes, well, the discharge of a gun releases immense pressures. It does so quickly that we often don't think about it. The pressure you use to actually inflate a tire is maybe on the order of 35 pounds per square inch. A 9mm Luger cartridge, when it discharges, releases pressures around 35,000 pounds per square inch, or PSI. These are just immense pressures, and they slam ammunition components into the gun. And that's the forcible contact that we're talking about during a firearm identification tool mark generation.
You talked about fire ammunition components. Would a cartridge case be, or a cartridge be, one of those ammunition components?
Yes, a cartridge case is part of a live round of ammunition or a cartridge. That's one of the types of components that we examine.
Okay. If you would, I want to talk in more detail about the cartridge specifically and its components. Go on to the next slide. Would you explain to the jury the cartridge?
Yes. So a lot of times people will say to fire a gun, you load it with bullets. That's not exactly true. What you need is a round of ammunition, also known as a cartridge. The top left image there, you see an actual photograph of a few cartridges. And in the larger portion of this diagram, there's a simplistic diagram of one round of ammunition. It has a few different parts. The first part is that cartridge case. It's a brass cup that essentially holds all the other components together. Jammed into the mouth of that cartridge case is the bullet. This is the actual projectile that's going to travel from the gun towards the target. Within the cartridge, you'll see some grayish material. This is the propellant or gunpowder. And at the very rear of the cartridge is the primer. This is a small metal cup. It contains some shock-sensitive explosive. When this primer is struck by a portion of the gun, called the firing pin, it explodes, causes the powder to burn very rapidly. At this point, the cartridge sort of functions like a champagne bottle being popped. The bullet is going to leave the cartridge like the cork from a champagne bottle. The cartridge case, that brass cup, is going to remain in the firearm at least for a period of time.
Okay. Going on to the next slide, can you explain to the jurors the different parts that we see here in slide number 10?
Yes, slide 11.
Sorry about my apologies.
No problem. It essentially is just showing you another depiction of what we just spoke about. So here we have two live cartridges on the outside of this photograph. Each of those is ready to actually be loaded and fired. Just inward from those, you'll see two cartridges of the same types, which I've actually pulled apart. So here you can see at the bottom, there is the cartridge case, that gold-colored round item with the writing on it that's facing us. The primer is in the center of that. The grayish black powdered material there is the propellant that's actually going to give the discharge its pressure. And at the very top of the center of the photo are two different bullets. These are typically going to be copper wrapped around a heavy lead core, and that's the projectile that travels through the barrel towards the target.
Okay, now that we understand the components of the cartridge, I want you to explain to the jurors the discharge process. If you would, let me get to the next slide. Can you describe for the jurors what we see here?
Right, so here we have a simplified diagram of a cartridge that's positioned within a semi-automatic pistol so that it can be fired. The cartridge is located in essentially a tube called the barrel. It holds that cartridge and it will guide the barrel bullet as it exits the gun towards the target. This cartridge is in the unfired state and it's ready to discharge.
And you said this illustration specifically is of a semi-automatic handgun, correct?
Correct.
All right, I'm gonna click it and it will show us sort of the actions or what's happening within the gun at the time the trigger is pulled and the cartridge is locked, correct?
Correct.
Okay. Can you describe for the jurors what the action was or what we saw in the motion on that animation?
Yes, so the first cartridge has discharged. The propellant burned and the bullet went down the barrel towards the right side of the image. At that same time, that pressure is actually going to be harnessed by the mechanism within the gun. It will cause the top of the gun, it's called the slide, to recoil, to move to the rear. This is going to use some of that energy from the first cartridge that's fired in order to prepare the gun to be fired again by a second pull of the trigger.
Okay. Would you describe the kind of bluish tinted area that we see in the handle of the gun there?
Yes, so that's depicting what's called a magazine. This component will actually be inserted inside the grip of this type of firearm. Magazine holds rounds of ammunition, stores them within the gun until they're ready to be fired. Essentially, it works like a Pez dispenser, if you're familiar with that, without the plastic head. So it's a box, it's got a spring in the bottom, and it pushes the cartridges towards the top. When the first cartridge fires, the top of that gun reciprocates, as you saw it move. This allows the gun to first remove the expended cartridge case from the chamber where a live cartridge needs to be positioned to fire a second time. It reloads that chamber with the top cartridge that's in the magazine. And it also resets the internal mechanism of that gun. When we say that a gun is semi-automatic, that specifically means that every time you pull the trigger, one cartridge is fired. It's going to function like a Windex bottle. I can hold the trigger all day, no more ammunition is going to be expended. So that is semi-automatic, as opposed to full automatic would function like an aerosol can. I hold the trigger and it would continue firing until the source of ammunition is depleted.
When you talked about the expended cartridge, that's the piece of the cartridge case that's left in the gun after the bullet comes out for what would be essentially a fraction of a second, correct?
Yes, that's the cartridge case. That's the brass cup. It's depicted in gold color on these particular diagrams. And that is the part that will be expended and ejected from the chamber.
How does that happen? How does it eject out of the gun?
Again, this is one of the functions that the mechanism is doing when it harnesses that energy. After discharge, there's a small hook in the gun called an extractor. It's going to pull that cartridge case out of the chamber, rearward from the barrel. It's going to hit it.
That is he going to be tied up the whole day?
June or after of this year. That would allow me
Proposal that might be a solution to our matter.
yes, Your Honor. Our request would be that we sever Mr. McMullen from the main trial schedule and set his trial to begin for a time June or after of this year. That would allow me the opportunity to be fully present and participate in the proceedings. I don't think it would disadvantage Mr. McMullen or even the state. When I've reviewed the evidence that I've seen thus far, Your Honor, his connection is very tenuous. He is charged with the RICO count. A lot of those things largely don't relate to Mr. McMullen at all. I think his connection stems from one main witness, and that witness would still be available. So I don't see the prejudice to the state. And also, I see significant prejudice to the defendant by either requiring me to remain or even trying to line up someone new with a short amount of time. I think a trial would still probably be starting around that same time. But I think this would allow the court to proceed with the other two defendants. This would allow the court to proceed with the other two defendants and respect all the rights with respect to Mr. McMullen's work.
Okay, well, I do think it would be a better idea if you feel like you'll be up to it once you get past your personal matter, your custody matter in April, to allow Mr. McMullen some continuity of counsel. You've been his attorney since July, and I think you're the only attorney who's been with him for any significant amount of time. And I know that you've been working on the case and you've gotten funds for experts and been pursuing that as well. So I would certainly rather you stay on the case, even if that means that it gets moved back a few months. One thing I would inquire about is if you believe you will be ready to try the case and fully present in, let's say, June. At that point, we're talking about, a 4-month delay. If we had to secure a new attorney for Mr. McMullen,
we'd probably need to give him or her that much time or close to that much time to get ready anyway. I know the state has opposed severing Mr. McMullen out because it's, a burden upon the state to have to try two cases instead of one when there is some at least alleged connection amongst these three remaining defendants. That mainly it appears being the RICO count, that is count one. If we move the entire case to June, you would be ready for that as well, because really your client's facing the two charges, whether he's facing them in a sole trial or he's facing them in a trial where he's one of three defendants. Is that correct?
No, I think that would be accurate.
Okay.
I would ask if it's possible that the court appoint additional counsel for Mr. McMullen in the event to continue to prepare the case.
Like to assist you
Correct.
for the next little while?
Correct.
All right, Mr. Lawimba has graciously joined us, I assume as a representative of GPDC. I had reached out because Mr. Dark is an appointed C3 attorney. Mr. Lawimba, I know you are just kind of parachuting into this matter.
So Judge, Mr. Dark, we already spoke. He's gonna, if the court is so inclined to move the case back to June, Mr. Dark is gonna rescind his withdrawal and he's gonna represent Mr. McMullen in June.
Okay.
If Mr. Dark is asking for an assistant to help him prepare for the case, that's something I can look into.
Okay.
To make sure that he does have an assistant, but he's still lead counsel.
Okay.
He's still going to be ready in June if this court is so inclined to move forward to grant his, because I know he has some issues, some personal things going on, to grant the continuance until June. So he will be there to represent him. And in between that time, Judge, within the next week or 10 days, I'll be in contact with you and Miss Rosser with that name, if anyone that we can get appointed to help assist him. Now, in all candor, that person that we get to assist him may be a paralegal. It may be somebody just to help do research or something. It may not be an attorney that files into the case.
Okay.
So that's also going to depend on, but I know he may need assistance with research, with kind of deciphering through the voluminous discovery. So I will try to get him those additional resources. So I don't want the court to look for another name to file into the case.
Sure.
That additional person may just be a really good paralegal that we can find and we can pay to help Mr. Dark throughout the process until June.
All right, I'm sure he'd be appreciative of whatever assistance you all are able to come up with. He's nodding in a sense, so that sounds good. If it is an attorney, great. If it's a really great paralegal, also great. So I appreciate you making sure that gets done.
Yes, Judge.
All right, so that'll be the plan. I know it's not ideal, but circumstances are sometimes beyond our control. So Mr. Lawimba, we'll wait to hear from you as to who that's going to be, and please let everybody know we appreciate the quick response. Well, he said a week to 10 days. So, all right. So thank you. So I'll excuse you and we'll just wait to hear from you in a week to 10 days on who that's going to be. Thank you.
Great. Thank you, Judge.
All right. Okay. So state, that means we can, we'll wait until everybody gets here to figure out what the new date's going to be. Oh, we've got somebody here now. Okay. Okay. Do you know, and I know that, apparently some things happened at the DeKalb courthouse yesterday and they got delayed, so they're doing closings this morning. Is that right? Yeah. Yeah. Well, yeah. Okay. So, Do you think that is he going to be tied up the whole day? Okay. Okay, because we're actually still waiting for the third attorney as well, who represents the third defendant, and I'm wondering, he's allegedly been on his way for about an hour, but I don't know where he was coming from. I think maybe Forsyth County. Oh, that's where you came from. So do we know, Mr. All right, speak of the devil, so to speak. Okay. Why don't we take a quick recess? We'll get everybody back in place, and then we'll go on the record and sort out kind of how to move forward.
So I apologize for that. I was creating the 403 emoji for my folks, but it looks like they're in a 15-minute session. We've caught up with the live feed, so as soon as they come back, we will be back. I am watching this time, y'all. So we'll just pop back over to ASAP Rocky from yesterday because, yeah, I don't know what happened yesterday. So I'm going to jump right back over there, and then we'll pop back over whenever YSL comes back. Here we go.
Another implement called the ejector. At that point, it's going to be flipped out of the gun. It essentially will appear like if you flipped a quarter as hard as you could towards your right shoulder. So that extended cartridge case will be cleared from the gun and remain in the vicinity typically.
Is that action that you just described consistent among all semi-automatic firearms?
Yes, to fire a semi-automatic gun, such as depicted here, more than once, you will have to clear the chamber of that expended cartridge case. It's a necessity to fire multiple times.
We've covered this a couple of times, so if you would just briefly talk about what the distinction between that action would be versus a revolver.
So a revolver uses a different mechanism. You may have seen these in Western type movies. Rather than having a magazine in a single chamber, there's a part called a cylinder. This is a cylindrical component that can be loaded with a number of cartridges. That component will then be rotated, bringing each cartridge in line with the barrel one by one, so that each can be fired. After that cartridge is fired, the cartridge case in a revolver will remain in the chamber of that cylinder until it is manually extracted and ejected from the gun.
Okay. We move on to the barrel of the gun. Would you talk about what happens in the barrel when the gun is discharged?
Right, so this is the portion of the gun that's most interesting to a firearm examiner during discharge. So I just enlarged that to the barrel. The rear part, you can see it's specifically made to accept that cartridge. That's the chamber. The entire device runs off pressure. So the rear of that barrel has to be closed off. This will be accomplished by a surface that's called the breech face. It's illustrated here in that bluish green. In the center of that breech face, there is a hole or a channel that allows the firing pin to protrude and strike the cartridge and initiate the discharge.
Now, specifically with the examination you did in this case, would you agree that a lot of the information that you were looking at comes from that area around where the breech face, the aperture, and the firing pin are?
Yes, a great deal of the information for cartridge cases in general, and in this examination in particular, will come from that portion of the firearm.
Because it's important to this examination, would you just highlight with the pointer exactly where those three different features are? The breech face, the aperture, and the firing pin?
Sure. So the breech face is going to be the forward surface of this blue block that's simplified for the purposes of the diagram. You'll see this channel that's meant to depict an opening in this solid breech face. The very opening forward portion of that channel is called the firing pin aperture. It's just the name we use for that hole, the opening. And depicted in orange, this simple cylindrical implement is the firing pin that will be propelled forward, strike the primer, and initiate discharge.
You said in your examination in this case, you looked at 2 of those fired cartridge cases, those brass cups, as you talked about, correct?
Correct.
You did not specifically evaluate any actual guns in your examination in this case, correct?
Correct.
So how is it that you were able to see any of the information that would come from the gun, meaning the breech face, the firing pin, or the aperture, if you didn't have a gun and all you had was that brass piece that was ejected from you?
Right, so again, this is an effect of those immense pressures and forces that are involved in discharge. Someone about my size stepped on a soda can. I'm exerting, I believe it's about 5 pounds per square inch. You can imagine that surface of the street could then cause dents into that soda can. Here we're talking about pressures in the order of 35,000 pounds per square inch. These are acting on surfaces of the cartridge case, which are not much harder or much different than you might find in the soda case. This allows just huge amounts of information to be imprinted into the material of the cartridge case, allowing type caliber determinations to occur and giving it a job.
Okay. Forward to the actual discharge process. Can you describe what we see on slide 19?
Sure, so here's depicted that firing pin coming forward, slamming into the primer, initiating discharge. Once that bullet has moved to the end of the tip of my finger, it is moving at the speed of a commercial jet, and it's rotating now at maybe 60,000 to 80,000 rotations per minute. So a great deal of energy has been released. The bullet's on its way out of the gun through the barrel, and pressure is slamming that cartridge case into the surfaces of the gun. This allows that firing pin to leave an impression. The firing pin aperture itself can be impressed into that primer with such a force that we can see the actual imprint, and also breech face markings. The small imperfections of that breech face can actually be impressed into the surface of the cartridge case, just as you would impress a fingerprint into a lump of clay.
Okay. This is an illustration that you have on the slide 19, correct?
Yes.
Did you put actual examples of these different components, the breech face, apertures, in your presentation?
There are, yes, some exemplars. There's only one, I believe, that's related to this case. These images, such as the firearm you're seeing, are unrelated examples.
Okay. What specifically are you showing here in slide number 21?
So what you just saw was a gun that's slowly been disassembled to show you the internal parts that are going to be in contact with the cartridge during discharge. We're looking on the left side of the image. We're looking rearward at that breech face. This is the surface that will close off the back door of that barrel, the tube behind that live cartridge. The main area is tinted blue there. That is the breech face surface. You look towards the center, you'll see a dotted line. I just added that dotted line around that opening. That opening is the actual firing pin aperture. And within the opening, you'll see an orangish sort of elongated implement. That's the firing pin. On the right side of that diagram, you'll see an illustration of the types of marks that we'll talk about. The blue area, that circular area, is the primer. It's a soft metal where that explosion happens on the other side of it. Marks from the breech face can come over. You'll see that dotted line outlining the firing pin aperture, and an actual impression into the material from the firing pin striking and causing discharge.
Okay, you said the illustration or the animation of the gun slowly being taken apart. I'm going to just go back so we can follow what you were showing. It goes by a little quickly, so I'll play again.
Sure, so the top is a slide and barrel. Now I'm taking the slide and the barrel apart. Here we're looking at the slide, which has that breech face surface within it.
Okay. Go on to slide number 22. Would you describe what you're illustrating here?
So a typical firearm identification task will often include what we call an actual microscopic comparison. I'll use an instrument to look at two marks on two items such as cartridge cases, with the aim of trying to determine if they are fired by the same particular source. You could come to an opinion that they were fired by the same gun, or an opinion that they were not fired by the same gun, meaning they've been eliminated. That information is typically most useful when there is a gun in evidence. So here we just sort of depicted that there's a firearm. Test fires from that firearm can be compared to the two evidence cartridge cases connected with the dotted lines down there. The cartridge cases depicted in different colors, sort of just indicating that sometimes the features of those actual marks will be sort of an apples and oranges situation. And we can tell, even without looking at the microscopic markings, that they were fired from different guns.
You said what's displayed up here would be an identification that you can make if you had a gun to actually compare the fired cartridge cases, correct?
That's what's most useful? Yes.
If you hypothetically had received a gun, in this case, to compare to the two fired cartridge cases, could you determine scientifically if that particular gun that was provided to you was the one that fired these cartridge cases?
I could perform a side-by-side microscopic comparison on a comparison microscope. If the marks are of sufficient quality, it may allow me to come to the opinion that, yes, the reason for the agreement of those marks is I'm of the opinion that they were fired in the same gun. Conversely, it could lead us to the opinion that they were not fired in the same gun.
That was my next question, was if you were provided, hypothetically, if you were provided a gun to compare to two fired cartridge cases, you could also definitively say, looking at these individual marks, that that gun was not used to fire those cartridge cases. Is that what you're saying? Is that correct?
Yes, there's identification, same gun. Elimination, they were not fired in the same gun. If there's any deficiencies with the items, we could just say inconclusive, meaning I can't give you any.
Mr. Katz standing in for Mr. Mondelli right now, and then we have Mr. Johnson and Mr. Dark, and all three defendants. And we're here for a pretrial conference, and we have sort of adjusted our schedule a little bit due to some matters that have been dealt with now, but we are now looking at a June trial date instead of a March trial date. So if everybody can look at their calendars, I would propose that we start jury selection the week of June 9th. And what it had looked like jury selection was ultimately, when we talked about jury selection before, I think I at least was picturing that we might be doing some of the beginning proceedings up in the big jury assembly room, but having talked to jury services, we're not going to be able to do it that way because they have a whole lot of other jurors up there at the same time that it just, there's not the right kind of space. So what we would be doing instead is having probably 60, 55 people at a time down here in this courtroom. And if we're thinking, which the last time we talked, we were thinking 400 or so should get us enough to choose a jury from, then that's 2 weeks worth of that, I think. We can, Monday, Tuesday, Wednesday, and Thursday is when they have jurors available. And so we'd basically do, 55 Monday, 55 Tuesday, 55 Wednesday, 55 Thursday, and then we'd have to do a second week of that as well. What I am thinking is that we could, at the same time we do the questionnaire electronically, which everybody should have gotten a copy of, and I haven't gotten any comments back about anything needing to be added or taken away, but I'll circle back on that in just a minute. Whenever we do that questionnaire, we essentially would just sit in here while they fill out the questionnaire. They hit submit and it goes immediately by email to each of the attorneys so y'all can immediately see what the responses are. I am thinking that even though we're going to have them all back again to do the individual questioning, that we could at least hear from people that first day they're here on potential hardships. And then we don't have to make a decision right then, but we can do that then. And then by the time we have them, there may even be some that, oh, it's so clearly a hardship, we don't even have to have them back. But that's kind of what I was envisioning, unless anybody has a strong objection to handling that part of it that way. Okay. All right. Okay, and I know we've got some motions in limine to deal with, but just in terms of the process for this first part of the jury selection, having had an opportunity to review the proposed questionnaire that would be on the electronic form, is there anything that anybody either has objection to having on there or feels like needs to be added? It largely came from what was used as, I guess, a paper questionnaire, the first YSL trial. But y'all let me know. Okay, thank you.
And good morning, Your Honor.
Good morning.
Opportunity to look at the highlights that the court had on the version that was
Yes,
emailed to us.
Uh-huh,
Then we were gonna go through it
sure.
by the highlights, and we have just comments per
All right.
highlight.
And of course, my copy is not in color, it's in black and white, so all of the highlights are gray. Because as you all know, I had some highlights that were for IT for purposes of putting the survey, uploading the survey, and then some highlights that were for us to discuss. So, oh, there we go. All right, so I think the first question was on page 7 of the survey about, would the question about, you know, have you served in a jury trial before? And then if yes, what type of case? Criminal, civil, court-martial? I don't know, or I don't remember, I don't recall. Is court-martial, is that going to cover enough for everybody of, have they been involved in a military case?
Yes, Your Honor.
No, I would, or been subject to any form of discipline under UCMJ. Because the military has judicial and non-judicial punishment.
Okay, so this was, we can add that question if it's not in there, but this was like, have you served as a juror before? So I think there's, later on, we maybe get to, you know, have they served in the military at all? So let's go through it, and if we don't see that question, then let's circle back. And it's under what was the discipline under?
The Uniform Code of Military Justice, UCMJ.
Okay. All right, so everybody fine with just, we ask, have you served in a court-martial?
Yes.
All right. The next question that I wanted us to discuss was on page 12. What's currently Q50? That was on the original survey that was used in the first trial, but it seems like sort of after this, we ask a lot of different detail about what kind of training, what kind of experience. So it seems like this may be covering the same thing and might be superfluous. Is that one that we could do away with?
The state agrees we can do away with it.
Okay. Any objection from the defense to doing away with that question, since we ask it essentially in greater detail in further questions later? All right. I do too. Is that all right with everybody? All right, so we'll strike that one. Okay. All right, and question 55 is actually, have you ever served in the military or armed forces? So I guess if we wanted to ask that discipline question, that might be the place to put that. Okay, so then, have you ever been disciplined under the UCMJ would be the question. Okay, let me jot that down. And then, you know, if so, we can ask them for details. All right, thank you. All right, I think next one is page 18. What's currently question 73. This is the way there was a question worded this way on the original questionnaire. Is this how you want it worded? Does anybody want to change that wording?
Your Honor, and to be clear, the jurors will complete this after either hearing the indictment or the summary of the
The
indictment.
summary of the indictment, yes. And we'll have to discuss how much
So
detail we want to include in the summary.
I'm not the best wordsmith, but I thought we could just ask, this case involves allegations for several individuals.
I think so too. Allegations against several individuals. Everybody okay with that wording?
Yes.
All right.
And then I think in paragraph, or in the second sentence.
The alleged events,
Surrounding these allegations.
strikes surrounding these arrests. And then I'm just going to say are alleged to have occurred between, and are those our correct dates still?
No, Your Honor, I believe it'll be March 2022. I want to confirm.
And then how about the beginning date?
Yes.
All right. It sounds like January 2015 to March 2022. All right,
Oh, and I'm sorry, Your Honor, April 2022.
April 2022, okay. All right, then our next question is on page 20. What's now question 80? And I was just unclear, and I think they might be unclear as well. The question currently asks about how much time you spend on the internet, and then they can choose different answers. And then the next one is how much time do you spend on social media? And they choose, do we mean how much time do you spend on the internet aside from social media? And then also, do we mean, or do y'all mean, these are your questions, time on the internet that's non-work time? Because I'd imagine some people have to be on the internet all day for their job. So you would get, 5+ hours is the answer. So do we want to clarify that question some?
Yes, Your Honor. And we thought that for question 80, the concern is more of how much time do you spend on social media?
That's
versus
kind of what I thought.
internet.
Okay. So then do we just, if we get the, how much time do you spend on social media per day? That's really what everybody wanted to find out?
No, Your Honor, I mean, as far as the combination of questions.
Yeah.
I believe that question 80 should ask how much time do you spend on the internet side?
Okay. So then maybe I'll flip the,
And I believe that both questions are necessary because what it does is it provides us an opportunity to see the delve into things that they may get into.
okay.
Outside.
All right.
Maybe law blogs or anything.
All right. So how much time do you spend on the internet today aside from time on social media? Or separate from social media? How do you want to ask it?
Well, I think the first question should be aside from her. That would give us.
Okay.
how much time there are.
aside from work, okay.
Yes, Your Honor. And then with the second question, how much time do you spend on social media? That would allow us to then delve into what are they on the internet
Perfect.
for outside of social media.
Okay, so question 80, how much time do you spend on the internet per day aside from work? And then the second question would be, how much time do you spend on social media per day? Does that work for everybody? All right. Sounds good. All right, page 29. And I guess this is more a question for the state than the defense, because the indictment and the evidence, it sounds like, are narrowed from our last trial. So which of these questions will we still need?
Your Honor, we think we do not need question 114 and question 116.
Okay. All right, thank you. The next page, page 30, question 121. Do y'all want the word paraphernalia?
We like items. We like
Okay,
suggestions.
we're going with items. Thank you.
Your Honor, and on page 31,
Mm-hmm.
question 124 is duplicative of question 53.
Thank you. So let's see, where's the better place for that question? Did you say 53?
Yeah. Word is slightly different, but 53 is, have you ever studied or received any specialized training or education in criminal street gangs? And 124, do you have any specialized training or education about street gangs?
My question 53 is, are you divorced? If you are divorced or widowed, please list your former spouse. So oops.
So I'm on page 13.
Okay. Oh, you know what? That's 63 and I just can't read or can't see. I can read, I just can't see. Okay, yes, there it is. Uh-huh.
I think it's better at question 53 than at question 124.
Okay, so let's strike question 124. Because it's already been asked. Thank you. All right, turning to page 35. Question 142. This is just how it was worded before. What is it we're asking at that point? Are we just saying, do any of you know these three defendants or their families? In which case we would just list those three defendants and their families?
Your Honor, we believe we need to ask for all 28 only because the case did involve these other individuals, and whether or not they have although their cases might be resolved, if they have a relationship that may or may not have a bias towards the state and the.
Okay, then it wouldn't be though who are defendants in this case. It would just be, here's a list of the defendants from the indictment, but we're not, okay. So it would just be, do you, a close family member or a close friend, know any of the following people? And then it would be the list of everybody who was a defendant.
Yes.
Okay.
Okay, so y'all.
All right, and then do you, a family member or a close friend, know any of the following lawyers? At that point, it seems like that's just the lawyers that are in this case, state and defense, right? Okay. Maybe we can see if one of those that's on this podium might work. We seem to need put new batteries in a lot of these mics again.
Yes, Your Honor.
Better.
As to this question, I believe that, if the question is asked as far as, do you, a family member or a close friend, know any of the following people? Given that the family members and close friends would not be on the stand, we would not be able to go into that relationship to understand how the family member or close friend would know any of these individual people as far as the showing of any bias in this case. So I do believe the question should be limited to the juror itself and asking them, do they have any knowledge of these individual people?
And it almost seems to me like the only way that they would know if a family member or a friend knew of whomever this is we're asking is if they too knew about it, because otherwise they're only speaking from their own knowledge. So would that work for everybody if we just say, do you know any of the following people? 142 and 143. Just say, do you know any of the following people? And it would be first the list of the defendants, and then on 143, the list of the attorneys that are involved. Does that work? All right.
And I guess, Your Honor, to clarify a little more, I understand that this language, do you, a family member or a close friend, is probably going to be asked in other questions as far as it relates to criminal activity or violence of
Right.
A victim of a crime.
Uh-huh.
I believe it would be more appropriate in those situations.
Agreed.
Because it may have a direct effect toward that individual rather than this situation we're just talking about hearsay knowledge that they may have from someone else.
Agreed. I think that makes sense. Thank you. All right. And then for question 145, and we'll make the same alteration. Do you know any of the following individuals? I have no idea who we're listing here. So I'm going to need a list. If y'all can get together on who we need to list, I would assume it would be all the potential witnesses and all of the victims, right? But I don't know, if it's the same as it was the last trial. So I'll need y'all to put together that list and get with each other and make sure you agree that it's covering everybody. So I'm going to write down here, attorneys will put that together and submit to the court. It can honestly be like, let's say April 15th, tax day. Because we do have to get we have to actually, I think, upload all of the questions, which might involve actually keying them in and then getting them to jury services and then running a test on it and all of that. So what do we say, April 1st? By April 1st. All right, the next page, I'm just wondering, is that the phrasing we mean? Or do we mean, do you actually know this person?
Yeah, so we thought, do you personally know?
Okay. Good with everybody to make that change? Okay. All right, and then 147, 148, and 149, do we need any of those questions in this case?
Your Honor, we think we do not need 147 or 148.
Okay.
We would ask, and I thought we asked this initially, but we are asking, have you ever heard of 30 Deep or Blue Jeans Bandit? Or the Blue Jeans Bandits? And that could be one question.
30, all right, so I'm sorry, 30 Deep or who?
Blue Jeans Bandits.
Blue Jeans Bandits. So do you want the sex, money, murder?
Yes.
So do you want 30 Deep and Blue Jeans Bandits as one question or as separate questions?
That could be one question.
Okay. All right. And that was all that the court, needed clarification on. So we've gone through those. So hang on, 151. Thank you. Good call. All right, let's look again at the, so if we start, yes. I'm sorry, 70 which? 71, okay.
Yes, I do believe on 71, we may want to add the word hearing in that, and that do they have any difficulty reading, speaking, hearing, or understanding the language?
All right,
And then also, I was just going through, and I understand that I did not see a question regarding hardship, and if I understand that you may go back and reorganize these some. As far as the statutory questions, the question regarding hardship, number 16 regarding residence, number 23 regarding age, and 34 through.
we're going way too fast.
I'm sorry.
All right, 16 residents, 23.
Is age.
34
and 36 are the statutory questions. I did not see a question regarding hardship.
It's question 151.
And I was just suggesting that if those group of questions could be grouped together and placed at the front of the questionnaire, therefore I believe that that would facilitate our determinations on those subjects moving forward.
Okay, so the kind of almost like 1 through 15 are, well, 1 through 14 are kind of like just identifier questions, like what's your address, things like that, which is kind of what we have on our jury summons that comes back anyway. The residents 15 and 16 about Fulton County. And honestly, like 17 and 18. Oh, how many years have you been a resident? And let's look back on page 4. So have you been a resident? Are you a resident of Fulton County? Have you been for the last 6 months? That would qualify them or not. So then after that, it's how many years have you been I guess that is Fulton County resident. I'll add that in so it's more clear. 18 is other places you've lived and for how long? Does anybody want that? I mean, I'm happy to strike any number of these if y'all don't necessarily want them. Okay, I mean, it's fine if you want it, that's fine, but if nobody really cares, then there's no point asking, so that's fine. How long have you lived at your current residence? It's easy enough to fill out, but does anybody actually care?
Yeah, I think we could strike 18 and 19, as long as they're a resident of Fulton County at the time.
I mean, I kind of agree, but Ms. Johnson,
The only reason that I would ask that question 18 be allowed, Your Honor, is because given the subject matter that we are dealing with here, this is a subject matter that these individuals may not have experienced here in Atlanta, but may have experienced in another jurisdiction or location.
Yeah, that's fine. So we've already found out how long they've been a Fulton County resident and then where else they've lived and for how long. Do we need 19? Anybody object to striking 19? All right, so then essentially the next ones are really kind of talking about, well, do you rent or own? Has to do with being a resident. And then it's just some more marital status things. Then we get 22, 23, and 24 are, are you qualified or not? And then what was the next one? 30? Okay.
The statutory questions on the.
So just move, you're suggesting move the statutory questions up before have you served on a jury trial?
Yes, Your Honor.
I don't have any objection to that. We can move those.
Along with the hardship question as well.
I'm going to ask the hardship question last. Because, I'm just going to ask the hardship question last. All right, so move 34 through 36 to so here's what it is. Right now, it's those age questions, residence questions, and then did you sit on the grand jury that returned the indictment, which would be a qualifier, and then it flows into, have you ever served on a grand jury? Have you ever served on a trial jury? And that is why it was before the statutory questions. So if we move it, I guess we'd move it to just below 23 before the grand jury question. Anybody really care one way or another? Okay. All right, so I'll make that question, put that in between 23 and what's now 24. All right, so going back to question 151, which is the last question on there, and which is saying, all right, here's when we expect this trial to be. Do you have any hardships? I'm thinking if we start and have 2 weeks of these questionnaires, the week of the 9th and the week of the 16th of June, that would give us, how long do you think it's going to, when we do, y'all will have a lot of information about the jurors by the time they come back for individual questioning. So how long do we anticipate it taking to do individual questioning of 400 to 450 jurors once we've got 37 pages of information on them?
Well, Your Honor, I know in the, as Mr. Eppinger was part of the first trial in this case, Judge Glanville went through the hardship part of the questions first. And once we eliminated all of those people, then we started.
Yeah. So that, what I'm proposing is while they are here the very first time, they fill out this questionnaire, and then anybody that has a hardship or thinks they have a hardship sticks around and tells us all what that is. And then we may not, some of them, we may just say, yeah, no, that's legitimate. We're excusing you. You can show up for some other jury some other time. So some of them, so we'll have questioned them about the hardship already that very first time we see them, the same day as the questionnaires, okay? So when we come back, we'll have gotten that out of the way. So when we come back, it'll be whatever y'all might want to follow up on from any of this.
Your Honor, and thinking through the last trial, it took sometimes between 30 minutes and an hour, but we had more.
Per witness? I mean, per potential juror?
But we also had more individuals, so
yeah,
it may not take as long.
We only have 4 people asking questions this time.
Right, so if you give each person about 20 to.
I don't anticipate. Why would we need 20, 40, an hour and 20 minutes per juror when we're already going to have 37 pages, which, you know, and a lot of them has a blank to give us detail of information about them.
Because depending on how many of the questions you followed up on.
Okay. Let me say this. We're not going to take an hour and 20 minutes per juror. Y'all are going to have to hone your questions, and it is not going to be tell me your life story with everybody. We don't need to know their life story. We need to know, are they going to be able to be a fair and impartial juror? So I'm used to striking a jury for a murder case and doing the entirety of it in a day, having 60 jurors and going through everything and having my jury by the end of the day. I don't intend to take 5 months to strike a jury. Okay, everybody clear on that? So let's realistically think about how long it's going to take.
Well, Your Honor, given the fact that the defense goes second,
Yeah,
we have the opportunity to hear the questions that were asked before and not repeat them. So
yeah.
we would be dependent upon the state's questions
Okay.
as far as the time frame in that matter.
Hey, Your Honor, just doing the math, it's 60 in one day.
Yeah.
It'll take 6 days,
Okay,
roughly.
so, all right, so if we do June 9th week and June 16th week as the questionnaires and the hardships, and then we have people back June 23rd week and the, beginning of the June 30th, July 1st, 2nd, maybe 3rd week. We're looking to start trial after the 4th of July. So maybe, like the evidence itself. So maybe we say on our question 151, this trial is expected to start in July, sometime after the 4th of July. After the 4th of July. Which is a Friday, is expected to start after the 4th of July and last somewhere between, are we all still anticipating between 1 and 3 months? Okay. All right. So I'll make that change to question 151. Any other comments, additions, objections on this jury questionnaire?
Your Honor, on the previous questionnaire, we had asked the jurors if they had social media accounts, their handles. Would the court be inclined to ask their social media handles?
No, the court would not be inclined to ask that. Anything else?
That if we're starting the trial in, I guess, after the 4th of July, then any juror who may potentially have travel plans on the 4th of July could affect the questionnaire process itself. So I was just wondering if we may want to flesh out in question number 151 what a hardship is in this particular matter, so that we can get a better indication.
Oh, yeah. I mean, it says, please describe in detail the nature of your potential hardship. And then we're also going to talk to them in person, face to face, that same day about what it is. Sure. All right, is that everything? We think we have our juror questionnaire? Yes, yes, yes. All right, sounds good. All right, one other thing I need to know, we all need to know, is the number of additional strikes that I might grant. I don't know if I haven't seen any requests for additional strikes, but we do have a 3 co-defendant case. Anybody have thoughts on that? Okay. Do y'all know how many you want? One apiece? And do y'all want to share them? Like 3 for the defense, or do you want to have 1 each? Or one additional each and 1 additional for the state? You get however many I want to give you. You want 3? No, it doesn't have to be equal. You want 3. I'll take that into consideration. It would be within my discretion. I am not going to be giving you 3 per defendant.
guess, Your Honor, my question would be, with the general fact that we get 9 per defendant, are each one of us gonna have 9, or do we have to share those 9?
No, you don't get 9 per defendant. You get 9. And then you're going to get a total of 12. So y'all let me know whether you want to sort out on your own. Does that mean 4 each? Or does that mean 12 pooled? Y'all let me know. You know what I mean? Are y'all gonna huddle on them all and decide on something, or are you just gonna, y'all will have to figure that out. And then we also need to sort out how many alternates we feel would be prudent for this case. We started with 6 last time and remarkably made it through a more than year-long trial, only losing 2. But I think so too. 4. Everybody good with 4? All right. All right, I'm trying to think whether there's anything else we need to talk about with regard to just the kind of jury selection process. Nothing's coming to mind for me. Anybody else?
Since I'm not that familiar with the case,
Sure.
my question is, I didn't see, and I just was able to look through questions this morning. Is there questions that relate to jurors having been familiar with the other part of the trial? Did any of them attend the trial? Did any of them watch it?
Yeah, I think that's.
I didn't see where that was. It may be, but I didn't see it.
Some version of that is on there. Let's look back. Sure.
Your Honor, to start from end of page 18.
Okay.
What number was it?
Question 73. And go against 70.
It goes through, yeah, 77. And then I guess it kind of, 78 and 79 are like kind of related, but don't exactly ask that. Now, it does not currently say there was a prior trial with different defendants, and I don't know that that would be appropriate to say anyway. So we're kind of asking more broadly about the case, your familiarity with the case. It's been in the media. Have you watched it?
Well, actually, I don't see a question in the purpose, but asking, did you actually ever attend the case? Is that how you gave your?
Okay, if yes, well, we could add it as a potential source on question 74, because if you have familiarity, from what source or sources have you heard about this case? I mean, we could just make another list of it, be like court proceedings or attending court. So I'm sorry, are you proposing add a fourth line that's I've attended court proceedings, or add a descriptor of, if they say I followed the case, describe how? Which would you prefer?
I prefer that they can.
Just the cleaner. All right, so,
Either 76 or
74 or 76? Maybe just, it might be a more clean on 74 than 76. Attended proceedings, attended. Does that work for everybody? Okay, thank you. All right. Now, we had a couple of motions in limine. So I'm going to move on to that if there's nothing else we can think about with regard to the jury selection process. All right, each of the defendants has filed some version of a motion in limine to exclude rap lyrics and or rap video. There was a ruling on this broadly in the last version of this trial, which everybody at least started involved in. One thing that is different is that since what was Judge Glanville's ruling, the Baker case cited by at least Mr. Mondelli in his motion has come out. That's a case from March of 2024, and I think Judge Glanville's ruling predated that. So I do want to give that consideration because that's a new case. I've looked at the case. I've looked at other cases about videos and lyrics. If anybody, I don't think I necessarily need argument, but if anybody wants to make argument, I'm willing to listen.
What, is the court already taking a position on it?
I've already looked at the law on it. I've looked at the motion, the response, the previous order, the case, and other law.
Well, the only thing I would say, Judge, is I've read that nauseam the Baker case. Actually, that's long.
It is long.
And it's still, I'm not saying it is a blanket rule as to whether video should or shouldn't come in, but certainly you still need to have a 401, 403, 404 determination, which I think would come with a ton of the state to come in, show those videos, pre-trial, determine whether they are admissible or not, what's the relevancy of it, whether it's more prejudicial than beneficial, and therefore have the court determine per each video, should it come in?
Okay.
And I don't think there's any other way to do it other than see videos. I've only seen 2 of them. I don't know how many there are. But the 2 I've looked at don't seem to indicate anything. And certainly in the Baker case, the state, I think, needs to say on the record, what is their purpose and intent and why they feel they need it in order for it to come in. Just because it's a rap video doesn't necessarily mean it doesn't come in. The 2 videos I saw said nothing about gangs, said nothing about killing people, said nothing about burying people, killing snitches, things that were referred to in the Baker case as far as what should or should not come in.
Mm-hmm.
It was just music videos. Really, they didn't seem that harmful to my client, although I've not seen the other 3. But certainly, my concern is, would juries have a tendency of having gang activity been such a big deal in the news and in trials, and almost every murder case now is considered a gang case? Does that in itself become prejudicial when the jury was to hear, oh, they're all rap videos and they're song from a rap video, not necessarily be a gang member. And that's what I think needs to be looked at very closely anytime that is entered into severance.
All right, appreciate that.
And,
Yes, sir.
we just had a brief argument, with respect to the 403, 404, analysis. The videos by my count, it's like north of 200, it's probably more, I'm still counting through. All of those videos obviously are not relevant to this case at this juncture. My client is not a rapper, he does not appear in any videos that we've seen. He's neither mentioned in any of the videos that I've seen. None of the alleged conduct that he was purported to participate in is mentioned in these videos. And so under that analysis, it just seems like overkill. It seems like the probative value, I don't see any at all whatsoever with respect to my client. I don't know with respect to the other clients, I don't know their status, if they are, rappers or not. I know my client's not. But the potential for the jury to just kind of lump him in with what's rapped about, I think is very high. Additionally, Your Honor, there's the argument that, lyrics are not literal. What's rapped about in a music video doesn't mean that you did it personally.
Right.
And so I'm just really, really concerned with the probative value, to me, based on the rules, substantially outweighed by the prejudicial effect.
All right.
I don't see any.
Understood. So I think we're dealing with, I'll let you have your say, but I think y'all are we are potentially needing to address two different things. I read these motions as sort of, I would like a blanket exclusion of any rap videos or rap lyrics because Baker says that should never come in. That's one issue. Y'all now seem to be saying there may be particular videos or particular snippets of rap lyrics that don't meet either 401 or 403. It is incumbent upon you, if you believe that, to file a motion in limine. The deadline for filing motions in limine already passed. Lucky for y'all, we've moved the trial date. I do not, since we are going to be starting this trial from scratch, want to be litigating what should be motions in limine about the admissibility of specific evidence during the trial. We now have more than sufficient time to litigate the admissibility of everything beforehand, but the defense is in possession of all of the evidence, right, State? Yes? Okay. It is incumbent upon the defense to identify what specific evidence they think is either not relevant or so overly prejudicial that it's substantially more prejudicial than probative. I'm going to give y'all yet a third motion in limine deadline. Anything not filed by that date, I'm just not going to entertain it, okay? Y'all know what you're supposed to do. So I'll get to what that deadline's going to be in a minute. But right now, let's focus on kind of what I am reading as more of just kind of blanket, this shouldn't come in because it is rap related.
Judge, in the position I take is that I don't see this being any different than the version of any different than the motion to suppress. We have part of the court, state wants to use those things. They come into the court, show us which videos they want to use, and the court makes a determination as to whether that's probative, whether it's relevant or not. I don't think for us that we don't have the burden going forward. That I think the state does because they will use it.
Well, I can get some clarity from the state about what evidence they intend to use, because I do think it's going to help everybody to, much like we did later on in the trial, really know what it is that is going to be presented so that we can all be on the same page about it. I want us to do that. But it is not incumbent upon them to say, here's Exhibit A. Anybody have an issue with Exhibit A? Here's Exhibit B. Anybody have an issue with Exhibit B? They're going to say, here are Exhibits 1 through 300. This is what we're going to use. And y'all are going to look at 1 through 300 and say, motion in limine as to item number 57, 73, 82, and whatever it is y'all want, and then we'll litigate them.
The other thing I'll say, and not having worked this court before, and I'm not trying to be argumentative, my understanding is that a motion of limine can be done at any time, even during trial.
If it only becomes apparent then, okay? So if there's some sort of evidence that they discover the day before, then maybe we're doing a mid-trial motion in limine. But if it is evidence that y'all have known for months before the trial was going to be presented, no. Okay, all right. Okay, so, I'm sorry, Mr. Johnson, did you want to say anything on kind of the more broad issue? Okay.
Snippet
Mhm.
to emphasize. So at this point in time, all we can do is object to, on the broad scale, to the introduction of all of it. Also on the ground that a lot of these videos can be possibly construed as improper character evidence, because if none of these videos say specifically specific things as it relates to these particular crimes, then the introduction of these videos, the backgrounds of these videos, the sounds and things that they may be doing in these videos could be construed as the jury as improper character evidence in this particular case. That's why we believe that they're highly prejudicial in this matter. And these videos in question do not specifically speak to any kind of crimes that the state are alleging that these people have done in this indictment or any other crimes. Then basically there's a situation where the probative effect is very minimal, while the prejudicial effect of all these videos are very high and possibly could confuse the jury and inflame the passions of the jury based on some of the actions and things that may have been said in some of these music videos, including holding guns, flashing certain symbols and stuff like that. And if the state is going to say that the flashing symbols and stuff is gang activity, they are able to present that evidence in other ways that may not be as inflammatory as the music videos in this case.
All right, well.
Your Honor, I'm going to be brief. I know this honorable court is well abreast in Baker and rulings related to this topic, but for clarity's sake, with the chart that the state provided to the court and defense counsel on the first page, which is what's in the redacted indictment, the only thing I would classify as.
Let me find the chart.
Yes, Your Honor.
All right, I've got it. Thank you.
So on this is from the original indictment numbering, but overt act 60, which is going to be one of the overt acts, the original overt act number 60. That is just going to be audio. There's
all right. Hang on.
Yes,
that is. So this is the 4-page chart.
Correct, Your Honor.
Okay, I'm looking at the right one, and we're looking at what is item 21.
Correct, Your Honor.
Overt act 60. Okay.
And for number 23, 2 down, there's no gun flashing or anything like that. It has a music video.
All right. So are both item 21 and item 23 going to be music videos?
Only number 23, Your Honor.
Some music videos.
Only number 23, Your Honor. And the reason I address that is that a number of either previously litigated or ruled on are not going to be, the state's not intending to introduce. So I wanted to make the court and defense, which this chart endeavors to do, narrow the universe of what would be classified as, a rap video that would fall under like Baker analysis. Right. The only other one, Your Honor, that comes close is if you go to the 4th page on this chart, it's number 13 on that last page. Original overt act 95. That's a very short clip, which the court is aware of these exhibits from.
Right.
But I also wanted to highlight for the court, just for note purposes, that all 3 of these, and I'll start with in order, Your Honor. So going back to number 21 on this chart, overt act 60, in the November 27th of 2023 order by the Honorable Chief Judge Glanville, page 34, number 5 is the one addressing that. And for number 23, Your Honor, which was originally Overt Act 78, if you go one page over to page 35, number 14 is that song. And then in relation to the very last one, Overt Act 95, on page 4 of our chart, the number is 13. In that order is page 36, number 18.
Okay. All right. All right. Do you have any argument with regard to the broad holding of Baker and if and whether it applies to this case?
Your Honor, just quite succinctly, and I know the court is aware of this, quite significant difference is that Baker was a malice murder trial, felony murder. It did not have street gang charges or evidence the state needed to prove to meet that, and it also didn't have racketeering or RICO charges. I think that is a quite significant factor that distinguishes the fact pattern in Baker, where that single video became a huge focus of that case, which was specifically addressing malice and felony murder, whereas in this case, there is a lot of other relevant admissible purposes such as association, a number of things that are unique for the street gang charges and the RICO charges.
All right. Thank you.
Yes, Your Honor.
All right. So my reading of Baker and case law surrounding rap lyrics in the context of a gang or RICO case versus in the context of a case that's not a RICO case or not a gang case, I do think there are some distinctions, and I think that's significant that Baker was not that type of a case at all. I am going to deny the motions in limine to the extent they are arguing that either because it's a rap video or because it's rap lyrics, it should be excluded from the trial. I am going to give y'all an opportunity to file motions in limine specific to items of evidence in this case, and it may be that a particular item of evidence, which happens to be a rap lyric or a rap video, might not be admissible, but we'll hold that for another day after we know what it is we're talking about with specificity. Okay, Mr. Eppinger has filed, or on his behalf has been filed, a motion in limine to bar the state from using particular language, including the words victim and crime. And I'm going to deny that motion. It'll be for the attorneys it'll be clear from the instructions that what is alleged still needs to be proven, and if not proven, acquittal is required. And it'll be up to the lawyers to do their lawyering to convince the jury one way or another with regard to what the evidence is. There's a motion in limine to prohibit the use of potentially prejudicial photographs, but I can't really make a ruling on that unless I know what photographs there are. I think this is talking about, it says crime scene photos or autopsy photos. Specifically, is there anything that I need to be looking at? Sure.
We believe that the state will possibly attempt to introduce photographs involving Officer Rogers and Officer Johnson.
Okay.
More specifically, Officer Rogers in this case, the individual who was shot, the police officer was allegedly shot in this matter by Mr. Eppinger. So we do believe that they may intend to introduce photographs of him as well as possible operating room videos and things of that nature. Improper in this case.
All right, so has the state, this chart, it tells us what overt acts are still, I guess, at issue and what evidence is going to come in with regard to them. Do we have a chart of, and I know we have a witness list, do we have an evidence chart yet of the evidence that y'all think you're going to use for? No. Okay. Now that we have all this extra time, can we get one? Okay. Yeah, I think we can't answer that question until we know what the evidence is going to be. All right.
The state does intend to use photographs to show the injuries that Officer Rogers sustained when he shot 6 times. I think the case law and the supporting law allows us to do that because there's a charge related to that, related to Epinger for aggravated battery in order to show and present to the jury that there was either temporary or permanent part of Officer Rogers' body that was rendered useless during due to the actions of the alleged actions of Mr. Epinger this time. I do believe the state is more than entitled to present those photographs. Now, I would agree with counsel, and I'm sure the court as it relates to duplicative photos that show the same thing over and over again, but the state has the right to present evidence in order to meet the elements of each crime charge in the indictment, and one of them is the aggravated battery.
Which one is the aggravated battery? That's not actually charged as a specific crime, is it? It's like is that like a gang charge or?
Or related to the attempted murder. So, Officer Rogers, I think we can.
Okay.
Prove that there was an attempted murder, the 6 shots and the damages.
All right. I don't disagree. I doubt if Mr. Johnson disagrees that there's case law that permits the prosecution to use photographs to prove their case. What we need to sort out is some photograph so hideously, graphically offensive that it should be ruled out, and we can't decide that until we know what the photographs are. So once you put your chart together and you know here are the 5 or 10 or whatever photos we intend to use, then we can litigate specifically. Right now, I'm going to deny that motion. It's just too broad to grant. If there's a more specific one later, I'll reconsider, or I'll consider it later as it is specified. Okay, well, there, just get your, okay. And again, y'all got the whole universe. And I think you have the more narrowed universe. But if we've all got it in some sort of a list or chart form specifically, then we can do the litigation that we need to do and then move on through the trial with an expeditious approach. All right, there is also Mr. Eppinger filed a motion limiting to limit testimony of state's witnesses. All righty, thank you. All right, the state has a supplemental notice of intent to introduce particular business records. Any issue with that? I think they've attached what the records, or the certificate of authenticities, the certifications. Anybody got an issue with that? It was some Instagram records. well, they're both Instagram records.
Or is that the one that sent?
Today or yesterday. Yes, I don't know what, yesterday or, yes, today, yes. Yesterday, okay.
And I haven't had the opportunity to review it. I'm sorry.
It's okay, it's only 3 pages, you can look at it now.
Your Honor, I've seen it, and I do not, as far as Defendant Eppinger, we do not have any issue with the certification itself.
Okay, sure.
However, I do believe that there may be some authentication issues to be raised at trial.
Okay, let's raise them prior to trial.
Well, the only issue is, Your Honor, based on the certification, they give an allegation of a number that is associated with a particular Instagram handle, and in the evidence itself, correlates from that number that Instagram is given to the actual profile that it purveys to come from, as far as to make a connection that these records are
From the profile, or that the profile is tied to a person?
that the profile is tied to the particular data here. If you look the name Big Chris, and there's a number associated with it, and that is the number from which the data is given. So the question is, how do we know that that number actually corresponds from Facebook itself? There's no showing there that that number corresponds to that particular profile itself. It was listed by the number, their number, the 646 number that they have on there.
I can show Mr. Johnson where the numbers correlate with each
Okay.
other within the record.
All right, if you'll do that, that'll be great. All right. Okay, we have a condensed state's witness list. Thank you.
And we just amended it yesterday, Your Honor, to add one individual, which was witness 104.
Okay. And we have I believe 2 people identified as gang experts. Is that right?
Yes, Your Honor.
All right. All right, any defense counsel have any issues with needing further information on how to contact any of those witnesses? All right. If y'all do, you don't have to wait until our next court date. You can just reach out to somebody on the state's team and let them know what you need, and they will endeavor to get that to you or somehow make sure y'all can get in touch with those people. All right. So I assume there are a lot of investigators that are going to be fact witnesses. There are a couple of people identified as records custodians or crime lab personnel. Just want to make sure if there's anybody other than the people identified as gang experts and then the FBI CAS team person that is going to testify in an expert capacity. I guess if you've got crime lab or GBI, crime lab certainly would be an expert. GBI, I don't know whether those are going to be experts or not. Just if there's any, it would probably behoove the state to go ahead and identify this person to be testifying as an expert so that we don't get to court later and have any kind of assertions that somebody wasn't aware that we're going to be an expert. Okay. All right. Anything else with regard to the state's witness list that we might want to go ahead and talk through now? All right. All right. This, I guess, redacted indictment that the state has proposed to use in this case. It lists all of the defendants and it lists all of the counts. And then
Maurice then set the standard for learning crime, and they ain't got right since, y'all. I don't know what just happened to the feed, but we just gonna give them a minute here to pull it together while we wait. Yes,
there's
y'all.
one way of doing it, but I've never seen it done that way before. Like when we're presenting this to a jury.
I was under the impression that's how we did it. The last year, I could be wrong.
I mean, I can go back and look, but I think there were a couple of counts that the court directed a verdict on, and we might have done it for those counts. But for counts that were not against any of the defendants then on trial, I feel like we didn't list them. I feel like we just listed the ones that the jury was going to have to render a verdict on. Because frankly, it's not that count 3 is removed from the jury's consideration. The jury wouldn't be considering count 3 because count 3 isn't against any of these defendants. Okay, so I don't think it should say that.
So do we leave it blank or do we renumber?
I mean, I think it's the language removed from consideration is just kind of potentially misleading.
You say not for your consideration?
It's just, it doesn't have anything to do with any of these defendants, so. Y'all think of something that seems a better, more accurate rendition. All right, I know one thing that I need to discuss with y'all is how detailed we want to get with our summary of the indictment when we're first saying, hey, jurors, here's a giant questionnaire. You might be on a 3-month trial. We need to know if you know anything about this case. I don't particularly want to read the indictment or even something close to the whole indictment 8 different times. Is there some summary we can come up with that is satisfactory to all of the parties that gives the potential jurors an idea of this is what they're talking about, if they're familiar with it? If they're not, then they won't know anyway. That is appropriate. Mm-hmm.
We believe that given the fact that these individuals are facing different charges and are not collectively charged together on every count, that it would be prudent to read each and every count to the jury so that they will be able to identify and separate each of these individuals with regards to their criminal responsibility.
All right, let me ask you this. That's true with regard to everything other than count 1, which is the verbose count in the indictment. Can we narrow count 1 in some way, summarize count 1 in some way that says count one charges a conspiracy to violate the Racketeer Influence Corrupt Organizations Act by a pattern of racketeering activity, maybe even just some portion of that part one, the conspiracy, without the entirety of the conspiracy is alleged, the entirety of the enterprise is alleged, and then the entirety of the still 53, is it still 53 overt acts that are alleged? State, is it still 53? Okay.
I had said the summary that included
Oh.
my very short,
Okay.
my jury,
I,
very short line said previously.
okay.
It just says this case involves members of the Young Slime likewise, so gang, including rappers and police, who are charged under the Racketeering Influence and Corrupt Organizations Act, also known as RICO, for engaging in a criminal enterprise and racketeering and other related offenses. These charges range from drug possession and sales, murder, and other violent crimes which defendants have pled not guilty.
Okay, well, that's a little slanted towards the state, but I'm sure we can use that as a starting point. It's certainly not going to say this case involves members of Young Slime Life, because that's something y'all need to prove, but good try. Okay. Y'all got a copy of that? Do we think we can take something, some part of that?
I haven't seen it yet.
Okay.
But it's also going to lead me to another issue about the jury questionnaire. We can take it now or later.
Okay. Are any of these three defendants charged with drug possession and sales? No, so we're not going to say that. All right, so the defense at least would want me to read with regard to, okay, here's what Mr. McMullen is charged with. Here's what, Mr. Eppinger is charged with. Here's what Mr. Garlington is charged with.
Yes.
Okay, and then, I mean, that's fine. Those are short enough and that's done normally. I guess so count one, which they're all charged with, is the one that I'm asking, is there some acceptable way to summarize that count instead of reading the entirety of the description and then all 53 acts, which take up 28 pages of the indictment? Well, no, that's not true. About.
Isn't the court going to have to read the entire document during jury charge?
Oh, the courts, well, during jury charges, but we're going to have already, done the case by then. I mean, I think at this point, when we're doing the, hey, here's what this case is about, that could be really short. And then typically I do read the indictment, or actually I usually have the state read the indictment because it's the state's indictment. It's not the court's indictment. But I'm happy to do, this is, generally a case alleging RICO, gang charges, murder, attempted murder, whatever the crimes are. And then they can read the indictment, but we don't need the entire indictment read just to figure out, here's enough about this case for you to say, yeah, I'm familiar with this, or no, I'm not familiar with this, or yeah, I've followed this before, or no, I haven't, right?
My only question is that kind of confusing to the jury, because not hearing it but for the first time at the end of the jury charges, is that going to require them, well, is that all we're deciding between the first year and then they're hearing 48 other counts later, is that going to create a problem for them to know what they're doing?
I'm trying to remember, and I don't have my book with me, that's what I read once we've got our jury. Do we read the indictment again then?
Yes.
We do, right?
I know there, you can, I know there is, but the indictment.
Let me. I would think they're paying a whole lot more attention once they're actually on the jury. And if I'm only reading the full thing once before we start the evidence, I think it would be more appropriate to read it when we've got our jurors in the box and I'm saying, all right, y'all, here's what this case is actually about.
That would be fine with us.
Okay. I'm looking back at my typical outline to see what I do. Okay, so I think what I typically do is read the whole indictment because it's not usually a 50-page indictment. During the jury selection process, and I don't actually read it again afterwards because y'all do your opening statements and you cover what you want to cover. But thoughts as to, my thought is if we're going to read it only once, we read it after we strike the jury. Does anybody have thoughts about that? All right, what do y'all think?
I would just suggest once.
Okay, and if it's once, do we think it's at the jury selection process or after we've chosen our jurors?
After we've chosen. I would agree with that.
Everybody on the same page?
I would assume that the issue that you're referring to is all of the overt acts.
Yeah, everything, yeah.
So I think that prior to the full one would be no problem to read, I guess, the statutory definition of the RICO charge.
Okay.
And then afterwards,
All right. All right. Okay, so that's how we will handle it. And it'll be the state, somebody from the state that actually reads it since they brought it. And honestly, I do that in every case, even if it's a 2-page indictment. I don't think the court needs to be doing that. The court's here as the arbiter. Okay, so we'll read the entirety after we have the jury. And it will be by someone on the prosecution team. All right, so we still need to come up with how are we going to summarize it for purposes of the jury selection. So we have the state's proposal, and I can probably just print this one page out for you, Mr. Katz, if you want to take a look at it while we're talking about it, and maybe we can, if I can figure out. Well, I think I just printed the whole thing, but it's pretty short anyway. It's just going to be the top part of that page. So what I had, this was just me kind of putting something together, and we can certainly change it, but I was going to say This case involves allegations of criminal gang activity and allegations of conspiring to engage in a criminal enterprise under the Racketeer Influenced and Corrupt Organizations Act, which is typically referred to as the RICO Act. The defendants are each accused of being associated with an alleged gang called YSL, or Young Slime Life, to have violated the RICO Act and to have committed certain other crimes. And you will also hear, I don't know, I don't think this is right, but you will also hear about a rapper named Jeffrey Young Thug Williams during this trial. Some of you may have heard something about this, you know, et cetera, et cetera. We can put more detail in, but that was kind of where I was starting from. Thoughts, or I could say, and instead of to have committed certain other crimes, I can say, and, you know, Mr. McMillan's alleged to have committed murder, Mr. Garlington's alleged to have committed whatever he's alleged to have committed, and, you know, list them all out. What do y'all think?
Yeah, I like the way you currently
I
have it.
bet. Okay. And I could also say including murder and attempted murder, murder or attempted murder. Certain other crimes, just the way I have it. Okay. Now, the part about, I know we need to at some point say something about this is the one that's connected to Young Thug, because that's what's, if somebody is familiar, what's going to trigger for them, oh yeah, I watched every hour of that case, you know, or no, I've still never heard of him. So how do we, I mean, I don't know if the way I have it is right, and I can't remember. Let me look and see what Mr. Abadi had suggested.
Did you have more commonly known as Young Thug?
No, I had a rapper named Jeffrey Young Thug Williams. I could say Jeffrey Williams, more, you know, who's, how to say it, music name, his rap name is Young Thug.
I think they would more so recognize it if it was.
Okay. Name Jeffrey Williams, who raps under the name Young Thug.
Correct.
Okay. Uh-huh.
Would you mind emailing what you're reading, just so I can see it?
Sure.
Thank you.
I don't know. You know, how about I email it to Ms. Rosser, who has all of your email addresses, and she can email it to y'all. Let's see.
Can I ask a question while we're listening to that?
Mm-hmm.
The form you just gave me, and I'm on my counsel here, specifically questions on this form.
Oh, we're not, you don't need to worry about those questions. That was the state's proposed questions.
I know, but enough of them.
You like. Okay, well, we can, and I know you're not the one who had this case before today. You're standing in for Mr. Mondelli. We can circle back on that. Okay.
there's been, the court is aware, at no point in time, any officers, any expert refused to speak with them. So what happened is they saw the defendant's testimony, decided that they wanted to introduce some evidence that they think is going to assist them. But in the end, Your Honor, even if the court said, you know what, it's timely, it's not.
Any fingers in anybody in particular, this, what I'm going to say, applies to everybody at the council table. There have been repeated speaking objections, arguing with witnesses has occurred, arguing amongst counsel, snide comments made from one counsel to another, arguing with a decision of mine. That's not going to happen. If it does, I'm going to invoke CCP 177.5, which allows for monetary sanctions up to $1,500 for each time. And what will happen is, each time it happens, that will be another incident that will occur at a hearing after the trial. I've never had to do this, but to ensure, or to help ensure, that these things that I just mentioned do not occur again. That is why I am doing this. So please keep it in mind that I'm going to keep track. Right, I understand that there's an issue of an exhibit that the defense wants to use. I saw an email exchange.
Yes, Your Honor, I'll address it. So it's not a new exhibit, no new video. So yesterday, Detective Flores testified regarding a sequence surveillance video, which is a compilation of the video from the 6200 Oscar Boulevard, the sound portion of that, overlapped on the video of 1616 East Del Mar. Video that we've had before was overlapped, and he described the process yesterday, testifying that when it was done, in fact, we wanted the impression we were informed that this detective did it. On the stand, he testified that he did not, and that it was sort of a rough approximation by hand in terms of how it was compiled. Given that, in his testimony that it evolved slightly, it would affect the sequence video. Last night, we used the same methodology that he described, did it ourselves, the same video that was provided by the prosecution, and with that compilation, once it was completed, we immediately sent it to the prosecution. We can lay a foundation for that. We'll do so through witness testimony. Interestingly, although the prosecution says that they make enough potential foundation, they were playing their sequence video to Mr. Efron without laying foundation for it. They introduced it with the detective yesterday, who was not the person who created it, in an effort to try to lay a foundation for it. We'll actually lay a foundation. How? We can have a witness who can testify to the events that are depicted on the video and ask him, is what you're seeing and what you're hearing a true and accurate representation of what you heard in the moment? That's enough for a foundation. There's two ways to lay foundations in our course. We are recording. One is the person who operated the equipment to say that it works, it functions, describe all that. Or to have the individual who's captured, or an individual who's captured in the video, just say that yes, that truly and accurately reflects what occurred. Do you have a video? Can you bring it up? Sure.
And you say you just created this yesterday?
Yeah. Yes. Yeah. Let us know when you're ready to hear from us.
Oh, I will. Is this impeaching?
No.
I have it on my screen. It's very, very blurry.
Yes, I think that's the reason.
Is that the video?
All right, we'll play now.
That's it?
Yes, sir.
All right, is there anything you want to add? Because then I'm going to listen to the, Mr. Lewin or Mr. Lewin. You? All All right, then I'll make a ruling. Once I make the ruling, that's the ruling. There's not going to be any further input from anybody. Do you want to say anything further? All right, the floor is yours.
Two issues. First issue is that the defense has repeatedly asked, repeatedly, if they had any real evidence they wanted to have. They just said this is not an impeachment, but it's even more than that. Unlike their witnesses, they have had access to the detectives in this case, to the video which they have had for a considerable period of time. And if they believe that there was an issue with it, they had an obligation to figure out what they wanted to do and to comply with 1054. But here's the bigger problem, Your Honor, and where I'm absolutely disappointed. The defense in this case, and this figures into 352, the defense in this case is that it is improper. According to the 12 offer of proof, and according to the evidence that the open statement is Katrina, the defense is they're not disputing this watching the video. They're not disputing that it happened. They're not disputing that it fired. They are simply saying it was a problem. So the second problem is by introducing this, what it appears to be is an attempt to basically mislead the jury as to what the issue is in the case. So in other words, at this late date, apparently they want to put on evidence to show that the timing of the shots doesn't match up. We've had no opportunity to review what they've done. We've had no opportunity to go back and see if it's legitimate. But the two reasons why it doesn't work is it's real evidence. This did not come up because the officer testified. Had they wanted to flesh out this information, they had opportunities to screen them. They could have contacted the detective himself. There has been, as the court is aware, at no point in time, any officers, any experts refused to speak with them. So what happened is they saw the detective's testimony, decided that they wanted to introduce some evidence that they think is going to assist them. But in the end, Your Honor, even if the court said, you know what, it's timely. It's not. Even if the court said it's timely. Under 352, Your Honor, the introduction of this evidence, the time delay, but more than that, the confusion of issues that are material to the case would tend to confuse this jury.
No. Right. First of all, since it was, the video was created as a result of testimony yesterday, I don't find that there's any violation of 1054.3. This is the way I view it. If the defense can show by competent evidence, if the defense can lay a foundation for the video, then they are entitled to show by competent evidence of their belief of the sequence of events. They're entitled to do that. That's part of the defense. If the prosecution disagrees with it, if they think it's inaccurate, they can present another version in its rebuttal case. So the ruling is it can be shown. All right. It's 10 o'clock. Let's have it. Can we look at this? All right, let's bring that.
Y'all, so it sounds like the defense has now recreated that video overlay with the gunshots and the body movement. So what we found out from the detective's testimony is that it was created. And so the judge has ruled that the defense can play their version and during their case in chief. And when it goes back to the state, they can then try and clean up whatever damage the defense has done. But we talked about this in the chat, y'all. We talked about this in the chat because how do we know that that sound lines up with the body movement? It could be placed anywhere to make it look like Rocky was shooting. Like we don't know. So we're gonna see what we saw the video, but I'm gonna see it again now knowing what I know.
Isn't that the only way he's going to come into the courtroom?
That's funny, Ron. That's very funny. I mean, we wait for the jury and we'll put them up there before they go in.
Oh, good point.
Thank you. That's all right. It's all right. It's early. It's early.
I guess we do need the jury.
That's all.
All right, let's bring in the jury first. but there is, yes. Let me ask you something to the sidebar now in the record.
We back on. We off the record, so the audio is off. But also, let's just highlight how Judge Arnold said, "Look, I ain't never had to do this before. All this back and forth yelling. I'm telling you, no speaking objections. Y'all arguing, that loud talking over what I'm saying. I ain't finna have it no more." He say, "Look him. For each infraction, you will be fined $1,500 each time. Now I ain't never had to do this, but the way y'all acting up in here, I don't have no choice. So we are going to keep a tally of how many times somebody interrupts, doesn't speak an objection, or overtalks, and we're going to compare that to how many times he issues the sanction. Now, I don't know if he's going to issue it over on the record. I don't know if he's going to say it in front of the jury, but I think it'll be fun for us to just kind of keep track. Yeah, D Wood, he says we only got 15 minutes left to hit our goal. I didn't even realize that. So our goal was to get 10 super chats. They're $2 a piece. We're at 4. So if you feel moved to do so, go ahead and help us reach our 10 that goal.
Any objection?
Sure.
All right, people 1 through 43 are admitted for the jury's consideration. The rest, the case is back with defense.
Or Mr. Mayers calls Janelle Phillips, also known as Shrugging.
Jamel Phillips, JAMEL PHILLIPS.
Thank you.
So loud, but that's okay. Yes. Sorry. You don't have problems with this. This is you.
Thank you.
Good morning, Mr. Phillips.
Good morning.
You go by any other names than Janelle Phillips?
Yes.
Go ahead.
ASAP 12.
So you're 12.
Yes.
What are we doing wrong? Sorry.
It's a bit on the loud side. Yeah, sometimes. All right, let's try that.
Okay, try it again.
ASAP 12.
Better? You don't have to jump into that mic. And it's ASAP 12 your stage name?
Yes, it is.
What do you do for a living?
I'm a musician, a designer, a model. I have a brand called My Last Year Being Broken.
That shit being broke?
Yes.
And what is that brand?
My Last Year Being Broke is a mantra like ASAP. So it's a program like a Big Brother program. We mentor kids. We mentor kids. We have back to school drives, studio sessions. I'm trying to get the studio sessions under insurance because to me, music is like medicine. Also, I sell apparel. I have therapeutic slides that I created when I was healing from an inguinal hernia surgery. And I'm also providing those to senior citizens.
When you say slides, is that like a slipper?
It's a slipper, yes.
And you produce and sell those, or in some instances donate them?
That's relevant, over 352 as well.
And so aside from music, clothes, the other programming, the therapeutic slide, anything else?
No, that's it right now.
As far as your music is concerned, are you currently recording?
Yes, I am.
Okay. Did you recently release a song on Apple?
Objection relevant, Your Honor. Sustain.
Where do you live?
I live in New York,
What part of New York?
Harlem, New York.
Where did you grow up?
I grew up between Harlem and the Bronx.
You know where Rakim is?
Yes, I do.
You know what any other names?
ASAP Rocky.
And you see it here, right?
Yes.
When did you meet Rocky?
I met Rocky when I was about 15, so around 2005.
Okay, and how did you meet?
I met him at it was like a rap battle, you know. Before we turned ASAP, there's some other kids that was like bubbling in New York. They had a rap battle in New York, and I met him.
And how old were you all about that?
I was 15, so Rocky had to be either 15 or 16. He's only like a couple months older.
How old are you now, sir?
I'm 35.
Where did you go to school?
In New York, at MLK High.
What does ASAP stand for?
Always strive and prosper.
And can you describe what ASAP is?
ASAP is a collective of not only brothers, women too, kids across the world, models, athletes, designers, philanthropists, you know, kids that took a negative situation and turned it into a positive.
And have you maintained a relationship with Rocky since high school?
Yes.
Would you consider him a good friend today?
Yes.
What was that relationship with him after high school?
So after high school, we kind of got closer because the founder of ASAP, Steven Rodriguez, ASAP Yams, he had us as artists of the label, you know. So we would get on the phone, still sharp and still get on the phone, work on our lyrics, work on our music, you know, just be there for each other, talk about the plans for the future, and yeah, just built a great bond.
And at that point, did you start seeing Rocky more often?
Yes, I did. So I would see him like at studio sessions, musical events, parties, hanging out in Harlem in the Bronx, see him often.
Is there a point in time where when you ever lived together? Excuse me.
Yes. So in 2011, when Rocky first got signed, he moved all the artists and his friends of the ASAP Collective to an apartment on 57th Street in New York City. It was a small apartment. We was in there like 20, like a group of 20 people. And to me, that was it was like it was great to see that somebody.
Sustain.
How about this ASAP Bills? Was he part of that group?
Yes, sir.
Tell us what he did.
ASAP Ills, he didn't create music. He was more like a model and a designer. You feel me?
There came a point in time where Rocky sort of hit it big.
Yes.
Okay. And were you there for that?
Yes, I was. We're all there for that. When he first got signed in 2011, like I said, he
Objection relevant, Declarant 2. Phillips, when you're asked a question, like a yes or a no question, just answer yes or no, or I don't know, or I don't recall. Don't volunteer.
Okay, no problem.
If the attorney wants to flesh it out, then I'll ask you another question.
All right, no problem.
All right, go ahead.
By the way, I assume it's your first time testifying in the courtroom.
Yes.
Okay. Did Rocky provide opportunities for you?
Yes.
Objection relevant. Overall.
Right.
Yes, he did.
And what were those opportunities for Rocky?
Objection 352. Overruled.
So Rocky was the first artist to be signed into a major label. So with that opportunity, he gave the other artists and ASAP record deals.
And, did you create music with Rocky?
Yes.
Okay, tell us about that.
I've been creating music with Rocky since I was about 16, 17, you feel me? And not only be able to create music, he gave me the opportunity to be his, I guess his hype man on tour. And with that, I will go to the venue, check out the venue, check out the layout, do everything that he would need to do before he gets to the venue and give him a rundown.
Okay, so when you said the words hype man.
Yes. Okay.
Tell the truth, what's a hype man?
Okay, a hype man is when you have a primary artist, which is ASAP Rocky, and then being that I was one of the, I guess, upcoming artists, ASAP 12E on the label, I was able to learn from him and learn the role, learn the business, and also learn the stage. He gave me the opportunity to, I guess, control the crowd serve, do everything that you have to do for a show, you know, and keep the crowd going, keep the crowd participation high. How you get.
When did you start doing that hype man thing?
I think 2011, 2012.
And when did you do that until roughly?
Till about 2016.
And what did you do after that? Do yourself 12 weeks?
So after 2016, the individual artists and ASAP had kind of established solo careers, you feel me? So I branched off to do a solo tour. And my first day of my solo tour, I ended up getting an inguinal hernia. And I couldn't be Rocky hype man anymore. And I had to slow down from traveling for a while.
What year was that roughly?
That was 2016.
And there's no point in time where you moved to California with Rocky.
Yes.
When was that?
We moved to California with Rocky in 2012. So in 2012, and then again in 2022 during COVID.
How about in 2020? We living with Rocky in 2020?
Yes.
Where was that?
That was West Hollywood in LA, yes.
In 2020.
2020.
And Rocky helped your career at that point at all? 2020.
Yes. In 2020, he helped me get out my Sony deal.
Get out of your Sony deal?
Yes.
Okay. So you had a Sony deal?
I had a Sony deal, and he helped me get out of it.
Out of it. So
yeah.
For whatever reason, you don't get into the details, but it wasn't working out for you, Sony deal, and Rocky helped you get out of the deal.
Yes.
Did at some point in time, you guys stop working together?
We probably stopped being business partners, but never stopped being friends.
Okay. When did you stop being business partners or doing professional work together?
Maybe like 2018 or so, you feel me? Because I was already ASAP 12, like a solo artist, and ASAP Rocky was building his label, but he was also signing other artists, you feel me? So I just felt the need to just work on my own career.
But you still remain close friends?
Yeah, that was my friend, my brother.
So you moved to California twice, according to your testimony, 2012 and then 2020?
Yes.
And what were you doing when you moved to LA?
Just creating music, working out, just building a bomb.
You know someone by the name of Withdrawal?
Yes, I do.
And you know him by any other names?
Yes. ASAP Relly.
And how'd you meet him?
I met ASAP Relly through the ASAP Collective. We all grew up together. We all grew up in the same boroughs. We used to hang out with each other, go to events, go to musical sessions, the gym. You know what I mean? It was a brother.
And roughly what year you met him?
I met him around the same time I met Rocky, so around 2005, 2006.
Okay. And tell us a story what your relationship with Relly was like.
I had a good relationship with Relly. We would get up, we would work out together. he had musical artists, so I would work with his musical artists, and we just would build a bond. Being that we were part of the ASAP collective, treated him like a brother, like everybody else in the collective.
At that time, in the early years, what was comparing the relationship with Rocky and Relly? Was it similar, the same, different?
In the early years, it was the same, you know, but when Rocky started getting way busier, I remember Rocky helped me get my passport. And from there, we traveled the world a lot. We weren't really be in like New York or the States, so I didn't have too much time to deal with Relly at that moment. But we would still speak and stuff like that.
When was the last time you saw Relly?
Last time I saw Relly was, I think the summer of 2022 in the Bronx.
So, well, tell us about that.
I was living in the Bronx, and he was living across the street from me. And this particular day, I was reading a book. So I'm reading a book outside. And
At this point,
Stand your arm, this is impeachment. Okay, approach you like. Guys.
continue.
Yes.
Okay, so I was reading a book. He lived down the block from me, and this is like the same neighborhood we would work out in. So you know we were known to see each other, but this is the first time I've seen him in a while. So I'm reading a book. I'm reading I think Who Killed Martin Luther King by James Earl Ray.
Relevance to what you read. You're right, but go ahead.
So I'm reading a book, and I see somebody like walking towards me. So at first, like I put the book down a little bit, and then I hear something. Then I hear something again. So then I focus and I notice it's him. And then like I catch him say something about like you know Rocky did bad by that team.
Your Honor, we need to approach on the, you've established, what you established, go on to something else. Your Honor, that's an issue, we do need to approach, I can't express this on the record.
That's an issue, that he has a story about. I don't know, y'all. I ain't gonna hold you. I ain't feeling a 12 story. I feel like he's an educated humanitarian. And I understand why he went into his background to try to make him seem like a very truthful witness. But this story, I don't know if I'm buying this story, y'all. It's it's a little rehearsed. There we go. Thank you, Ash. You pulled it out of me. He's a little rehearsed. I was reading this book. I was reading Who Killed Martin. What? Like, bro. I don't know. We gotta see. We gotta see how this continues. So I'm assuming that the prosecution is upset by the fact that he's saying that Relly approached him saying that Rocky was wrong or something. So yeah, I think it's very, very interesting how different the witnesses are as they come in and come up, right? We've had Relly, we've had Wally, and now we've got 12, which is crazy. All their names got a E on the end of it. And he's a little rehearsed. He is actually, I think we are a little behind. We may be able to skip past this. We are, and we can.
Question is stricken. If there was an answer, it is stricken. Go on to another topic.
Are you aware whether or not Rocky had been the victim of prior violence?
Yes.
You have personal knowledge of that?
Yes.
Okay. Tell us about the first instance you're aware of that you have personal knowledge of that you saw.
Well,
Your Honor, same issue, no discovery in this area.
Not true, Your Honor. Why he was carrying that weapon. No, that's not a reported statement, because their police reports are not so.
It's in the summary, overall.
Okay, 2018, you said?
Fifth line down.
Yes.
Go ahead, tell us about that incident.
In 2018, I'm not too sure what club it was, but we was in a club having a good time, and a brawl broke out in the club.
Objection, did we have? Overall.
A brawl broke out in the club, and we got jumped, and we both ended up cut inside the club.
And when you say both, yourself?
Yes, I got stabbed, and ASAP Rocky got stabbed.
Okay. How about another instance that you were personally aware of or saw yourself?
But several times I would be at his crib in LA and stalk his house. I would pull up to his house in LA when I was staying there, and several times while I was staying there, stalkers would pull up to his crib.
And you saw that?
Yes.
And you remember what years that was, roughly?
That was 2020 and 2021.
And were you there when there were any home invasions?
No, I wasn't, but I definitely heard about the home invasion.
Objection calls for hearsay. Sustained. Move on to another topic. We established what you intended.
Yes, sir.
Motion to strike the answer given.
You sustained, Your Honor. It's no more sustained.
There was an answer, or the question and the answer are stricken. Jury can disregard. Go ahead.
Do you know any security measures Rocky took in response to those instances you just testified to?
Yes.
Tell us.
I know he had to get a whole new security staff, and also I know he walked around with a prop. Like a starter pistol, like a prop. As in the defense.
Okay. And how do you know he had a problem?
Well, I've seen it on several occasions. The first time I seen it, it wasn't on his like body for anything. It was for a video shoot, the DMV video shoot in the Bronx.
When was that?
That was July 2021.
And you were at that video shoot?
Yes, I was.
You were actually part of the video shoot?
Yes, I came in the video.
Okay. Who else was in that video?
Me, myself, Rocky, ASAP Ills, Rihanna was featured in the video as well.
And in that video, you said you saw prop guns?
Yes. So he had a scene that was more like a private scene. Not too many people could be around the scene, and in the apartment, they were having like it was like a mini movie, you know. So he had props, he had different things to make it feel like a movie set in that scene.
Okay. And after the video shoot was complete,
yes,
did Rocky do anything with any of those prop guns?
Well, I'm not too sure about the video shoot, but I do remember seeing him again with a prop. September of this year.
Same objection, Your Honor. Sustained. Not responsive.
Okay. After the video shoot, did you see him with a prop gun again?
Yes.
When?
In September.
Of what year?
2021.
Where?
In Harlem.
For what?
Well, I remember I was getting food on 143rd and Lenox, and he happened to hit me. I told him where I was at. He came to see me. And
you ain't say he didn't hit me.
Oh no, he contacted me.
Yeah,
I'm sorry. He contacted me to see where I was at, and I was uptown getting some food on 143rd and Lenox. And we met up. It was like a block party in Christian on the same street. So Christian Street, we went to eat in the park, and I just remember when he was sitting down, seeing something like bulging out his white T-shirt, and I asked about it. He showed me, and it was the same situation from a DMV.
He told you it was proper.
Yes.
Motion to strike is hearsay with the defendant's sustained.
How about in California? Did you see that prop in California?
Yes.
When?
Your Honor, objection, no discovery.
You could, I mean,
Okay, so when I came back to California for I think it was the Complex Con event, that week we would like work out early in the morning. We go for bike rides around his area, and this is still like COVID area, so he didn't have security, and that was basically like his line of defense. If anybody ran down, he and he would have the problem.
And that again, that was September 2021?
September 2021.
Do you yourself have any familiarity with STAR pistols or prop guns or replica guns?
Yes.
Okay, how do you have familiarity?
In a couple of my music videos, I've used replicas and props. And being on set with Rocky, I came to be knowledgeable of, having props and certain equipment that make a music video look like a better production.
Do you know in particular one music video that you use prop guns in?
For my music video? Oh, yes.
What's the name of that?
It's called Escape.
So, according to you, you saw Rocky before November 6th with the prop gun 3 times.
Yes.
The NB video.
Yes.
The time in Harlem.
In Harlem.
In September 2021, and then Los Angeles.
Yes.
When you saw the prop gun in September 2021, was it the same as you saw the DMV video?
From what I remember, it was a bit different because now it had a belt clip so you can secure it, and I think it had like a clear clip, I guess replica magazine. Yeah.
And in Los Angeles, did it look like it looked in New York?
Yes.
And that was November 2021?
Yes.
First few days?
First few days, yes.
And let's direct your attention to November 6th, 2021. Were you with Rocky that day?
Yes.
Okay. What were you doing that morning or that day?
Oh, that morning, I remember we worked out because we wanted to get our bodies ready for the Complex Pawn show, which was the next day. So I was staying at the little perk, met him at his crib, worked out a little bit, and then around, I think, 5 or 6 o'clock, we headed out to Long Beach.
Who were you there preparing this performance with?
The ASAP Collective, from what I remember, it was me, Rocky, Ills, Lou, a lot of our friends from New York, a lot of the friends from the collective. It was the 10-year anniversary of Live Love ASAP. It was a big deal. It was also the first show for him or anybody else in the past 2 years because of COVID. So it was a pretty big deal.
You mentioned the name Lou. Who is Lou?
Lou, ASAP Lou is he's a member of the collective, but he's also I guess Rocky's manager.
And at any point on November 6th, you see ASAP Lou holding Rocky's property.
Yes. So I guess when Rocky had
anything after yes is restricted. So the answer is yes.
I'm sorry. Tell us the circumstance of how you saw Lou holding Rocky's property.
Yes.
Objection, no discovery.
So Lou, he also works, as a manager. He works as a stagehand. He has multiple hats, and I just remember that day. I guess he just had to get it from Rocky while Rocky
Objection,
performed the
calls for
set.
speculation. Sustain. Motion to strike the answer.
What did you see? Well, yes.
Oh, I seen Lou with the prop.
Which prop?
The same prop that I seen in New York.
With belt clip?
Yes.
With that sort of replica magazine extender?
Yes.
What is your understanding, sir, as to why Rocky was carrying a prop gun instead of a regular gun?
Objection, that's been called for speculation. The end of your say.
All right. Let's direct you, by the way, what is your understanding? Just to be clear, what a prop gun, STAR pistol, replica gun, whatever it's called. What is your understanding of what it is?
It's a device that looks and sounds like a real gun, I guess.
And you've seen it used in,
Yeah, my music videos, I've seen it in movies, I've seen it in his music videos, I've seen it several times.
All right, I want to direct your attention now to November 6, 2021. On that day, we with Rocky were in an altercation with Relly.
Yes,
Who else was with you?
ASAP Bills,
Okay, and ASAP Bills is other name, his real name is,
Elijah Ulongo.
can you tell us what happened from the beginning of that day?
Okay, so we were at the conference call rehearsal getting ready for the show tomorrow. And everything was good. We was having a good show. And towards the end of rehearsal, because I'm on stage with Rocky, I just I see him kind of like dealing with something on his phone. And he kind of put me on to it. Relly was online, just like disgracing his name, running his name through the mud. You feel me? So Rocky was like, "Yo, bro, I wanna go holler at Relly. I'm gonna go talk to Relly." You feel me? And I was already with him at Complex Con, so that's why I went with him. And he asked me to call Relly, text Relly, but Relly didn't respond to me. You feel me? But Relly was still responding to, I guess, Rocky.
This is the narrative, it's also no discovery. Ask another question.
Okay. You remember if Rocky was dealing with something on his phone?
Yes.
Did you hear his end of the conversation?
Just not the end of the conversation.
His end of his part.
Oh, yes,
What he was
yes,
saying.
yes.
Okay. And did that have to do with bad mouthing Relly or Relly bad mouthing Rocky about Josh's funeral?
It was Rocky explaining to me how Relly was bad mouthing Rocky about not handling Josh's funeral.
Objection, that's in call for extended, motion is strikes. And also no discovery.
You weren't, going to speak on that, but,
No.
okay, that's the approach.
No.
All right. So, who was Josh?
Josh,
Objection, relevance, and 352.
Josh is ASAP Josh. He was a member of the collective that passed away in October 2020.
Who paid for Josh's funeral expenses?
Objection, relevance, and 352. This is that.
Do you know of a dispute between Relly and Rocky about the paying of Josh's funeral?
Objection, relevance, and 352.
Yes.
Okay.
I guess.
No.
Yes.
Hold on. Yes, good.
Answer the question.
And what do you know about the dispute?
Objection, that's going to call for a narrative. He's aware of the dispute.
Now, the next day was complex time, you said?
Yes.
Did Rocky, in your presence, attempt to reach out to Relly?
Yes, he did.
Through the air before complex time?
Yes, he did.
And at complex time, were you all supposed to be going together?
Yes. Well, from Complex Con on the 6th, we were all supposed to go to the Playboy Cardi concert as a group, as a collective. And then the next day, we were all supposed to perform at Complex Con as an ASAP collective.
And why was that an important day? Was there anything specifically important about that next day?
Objection, relevance, and 352.
Yes. It was the 10-year anniversary of the project that got ASAP Rocky and the ASAP collective signed.
Did you hear Rocky speaking to Relly that
Yes.
day? Okay. And was that on the phone initially?
Yes.
What did you hear Rocky say?
Objection, hearsay.
Thing, you can ask to describe the tenor of the conversation,
Sure.
but not the words.
Okay. First of all, before I ask you about the tenor of the conversation, you personally, did you try to reach out to Relly that night, November 6th, 2021?
Yes, I did.
How did you try and do that?
I believe I called him and I texted him.
Did he ever respond to that?
No.
Okay, you heard the judge, you could describe the tenor of that conversation without words. What was the tenor of that conversation? You know what I mean by tenor of that conversation, the sort of the atmosphere of the conversation, the mood of the conversation.
Okay, from what I recall, I feel like it was like a humorous, brotherly conversation. Yo, where you at? Like, all right, let's have this conversation. It wasn't nothing more than that.
What was Rocky's tone like in the conversation?
Well, being that we was coming from complex calm, we got a big show, he was in a good mood, you feel me?
Hold on, it's not responsive.
No. Forget about this mood. This is my question. Yeah, I know this is not your everyday thing. What was Rocky's tone during the conversation?
Happy, sad, angry,
It was on the phone, it was kind of happy, it was just more or less trying to.
Right, you can ask the question, go ahead.
Now, was Rocky talking calm?
Yes.
What happened after the call?
Objections, call for a narrative.
Well, after the call, because we were in Long Beach, we had to go from Long Beach back to LA. So really, we was just in the car playing new music, getting vibes together. Everything was like exciting. Everything was like happy.
Who was driving the car? You see in the car?
I think we had a driver. It was complex call. We I believe they provided like traffic.
And you eventually get to downtown LA, this parking garage on Argyle Street eventually.
Yes.
Okay. Where were you sitting in this car?
I was sitting in the back.
Okay. When you stopped and got out, who was the first to get out and who was the last? The three of you.
Okay, Rocky, then Ills, then me.
And what did you see when you got out?
So when I first got out, I was just seeing Rocky walk up the hills, Ills walk slightly behind him, and I seen brother coming down there.
And when you saw Relly coming down the hill, describe what you saw.
So as I'm looking up, I just see like Relly coming down the hill with a little extra momentum, not running or anything, but just a little pep in his step.
And did there come a point in time where Relly and Rocky met?
Yes.
Okay, what happened when they met?
Well, as soon as they met, from what I've seen, it was just like Relly just grabbed Rocky. It's just as soon as he seen him, just grabbed him.
Okay. And what happened after he grabbed him?
So he's kind of grabbing him, and Relly's a big dude, you know, Relly big. So he's kind of like grabbing him and shaking him. So at this point, Rocky tries to like, I guess, grab him too, but grip the floor so he can maintain his balance because Relly was kind of like trying to lift him up by his hoodie.
Now, at one point, we'll just play that video. We have that. I'm going to show you a video from that garage in Calvert, Argyle Street on November 6th, 2020.
Which exhibit?
No problem.
Is this the one that,
This is the
oh,
garage.
E.
E. Is that an E? No, no, it's not E. Emma, as in Mary?
Yes.
M as in Mary.
Like this.
There's a power button on the side.
My side?
Yeah, just at the top.
Well, you could look at that little screen over right behind you. There's a sort of video on it. So maybe easier for you to see. I'll play it through once and then I'll ask you about it. Okay, keep that there, I might need to refer back to it. Keep turn around. That, obviously, it's just a small snippet with an obstructed view, but is that part of what you saw?
Yes.
Okay. And when you see them going backwards towards that parking sign, I guess Relly is holding Rocky, right, holding Relly and going backwards that way. What did you observe?
I observed, like I said, Rocky was trying to get his balance so that he wouldn't like lift him or throw him or push him anyway. But
Let's
That's
say-
that's the call for speculation as to why.
The answer is, remains as is without adding.
Okay. And then, what did you see when they were going backwards?
I seen really like pulling like Rocky.
And what was your reaction? Your reaction?
Well, my reaction, I was surprised because from my understanding, these dudes were only supposed to have a conversation. You know, I didn't expect anything else.
Did you do anything?
Besides try to break it up, you know, just put my hands in the middle of it.
You see yourself on that video at the end there?
Yes.
You're wearing that red jacket? Is that right?
Yes.
One point, is that Ills who gets in the middle?
Yes.
In that small clip there, you see Rocky holding an object that looks like a firearm.
Yes.
Okay. And what was that in fact?
That was his pride.
And tell us how it came out that he saw holding it.
From my recollection, being that Relly's a big dude and Relly was
Objection, most
Stay,
instructions,
stay.
non-responsive.
Stay.
Court instruct the witness to answer only when asked.
Out to, ironic.
Ask the question again.
So. Trying to know how to ask it a different way.
Ask him what he saw, ask him what he saw.
Just,
as I said, I seen Relly grabbing Rocky, almost picked him up off the ground. And with that happening, his pants started falling.
it's me.
The Rocky pants started falling. You know, so
Did you see that in the video there?
yeah.
Okay, go back to that clip, please. Just want to make sure we're talking about the same thing. When we come back from that. You see Rocky's pants down there?
His lead, sustain.
Okay, what do you see?
I see him right there.
Yeah.
So his pants are lower than they're supposed to be, and then I see him try to put his prop back, like adjust it back into the belt.
Which hand was he holding that prop with?
His left hand.
Is Rocky left or right?
He's a right.
What did you do at that point?
At that point, I just stepped in the middle and just tried to break it up. And also, I was trying to tell Rocky to go, like, yo, bro, we out of here. Like, Relly's going crazy right now. Let's go.
Objection, motion strikes, non-responsive.
Okay. Why did you tell Rocky to get out of here?
Well, because, for one, I see that the conversation that they were supposed to have, it didn't look like they was gonna have a conversation, and Relly was a bit aggressive. And I didn't understand that. It's like, we all friends.
Objection, motion strikes, non-responsive.
Everything after we're all friends is true.
Okay. Who's the aggressor in this encounter?
Relly.
Okay. Is that why you told Rocky to leave?
Yes.
Okay. Did you ever see Rocky point that object, just a prop gun toward you, at Relly at all during that parking garage encounter?
No.
You ever see Rocky press a gun, prop gun that you described here, against Relly's stomach, to point at his head or his chest?
No, I did not.
Would you have seen that if it happened?
Yes, I was there.
When Rocky pulled out that starter pistol, did Relly say anything?
Yes.
What did he say?
told him to shoot that fake ass gun.
And how, and you heard that clearly?
Yes.
And how fast was this altercation?
It was pretty fast. Pretty fast.
After it was over, and like you said, you tried to push Rocky to go away, what did you all do?
We ended up turning the corner.
Okay, maybe we should put the map up real quick. If we keep it in the fine. I'm gonna put, Mr. Troy, Mr. Phillip, I'm gonna put the map up here so it'll help acclimate. People stoop, people stoop in the front line. Okay, see where that red pen just was?
Yes.
That's Argyle Avenue, that's where that parking lot was, parking, arrow parking, right there, you see that? Right there. There's a point or something, I think, so. Yeah, use that thing. Just go up there. That one. Yeah, just do like this, like, here's Argyle, here's the parking lot, right? Okay. And then here's Selma, right? And then, here it is, thank you. Here's East Delmar, so just show the jury from the parking lot to Selma, East Delmar, which direction they're going here.
Mr. Secretary, one of the participants needs a break.
Okay.
So,
Sure.
10 minutes?
Yes, sir.
We'll take a 10-minute break, folks. Please be outside the courtroom for 5 minutes after.
All right, y'all. Let's see how far behind were we. Only a few minutes. So we are caught up to the live feed for real this time because I totally forgot the last time. But here we are. So D Wood or anybody, just go ahead and close out of the chat and come back in and let me know if you see the sauce emoji. I got my boy D Wood's a sauce emoji because he always asks, do I got some sauce on it, or telling me I need to put some sauce on it, which equates to turning up the speed of the audio. But all right, y'all, let's jump into ASAP 12B's testimony. Well, what have we learned from him thus far? That he is a musician, designer, and model with the ASAP Collective. He came in spiffy. He came in professionally dressed and wrinkled. He makes music. He met Rocky at a rap battle. All right. He used to be his hype man, and he continued to basically, work with him while he worked on his career. He's testified that after a fight in the club and after some basically break-ins, that Rocky started carrying a prop pistol. He's also alleged that he was around during the conversations that led up to the event, in which he described as humorous, and he described Rocky to have been happy or cool during this encounter. I don't believe it. I'm not buying it. I'll tell you that he definitely sounds rehearsed, and I'm worried about how he's going to hold up over on cross-examination. He then tells us that Relly was the aggressor. He came down from over the hill or wherever he was they were walking to, and he grabbed Rocky. He's alleging that he grabbed him and kind of basically manhandled him because he's physically so much bigger than ASAP Rocky himself. He claims that Rocky's pants fell. He tried to grab him, and then he also pulled out his fake starter, prop gun, starter pistol, period. He's also testified that he is familiar with prop guns himself because he's used them in his videos, but he was really introduced to them and got familiar with them just by hanging around and being out with Rocky on video shoots and movies and things like that. So he again has alleged that Relly is the aggressor. He says that he snatched him up, and Rocky held the fake gun in his left hand when Rocky is indeed right-handed. He's also put in front of the jury that Relly said, shoot that fake ass gun. So, I don't know. Okay, oh, wait a minute. I gotta go back. I gotta go see the sauce emoji. Is it small? Okay, y'all. For whatever reason, my chat is like catching up. Let me refresh this. Because, I can't see it on StreamYard. So that's why I have to, like, go over to another chat to see it. I don't know how big it is, though. Let me. Ooh, that sauce emoji is small. It is small, y'all. I will make that bigger because, child, who can see that? I don't know. I don't know who would be able to see that. I'll make it bigger. But I actually just learned how to make it transparent. So I'm going to actually fix the other emojis so that they are all transparent too. I want my stuff to be transparent. So I just learned how to do that while we were listening to 12E. But all in all, y'all, I don't feel like 12E is coming off. When he was telling his before story, it didn't seem like he was coming off as genuine. It came off as very rehearsed. Now, once he got into like what happened, now I feel like it's coming from memory. Is he choosing to tell which part of his memories that he liked? Absolutely. But I do feel like this part is actually coming from memory. Now, what y'all think? Tell me what y'all think. Tell me what y'all think. I'm fixing that emoji, y'all. So throw y'all comments in the chat. I know y'all in there eating me up about this little bitty emoji. I know y'all in there eating me up about it, but it's okay. I'm about to fix it. I'm about to fix it right now. Okay, it didn't save. It didn't come over here yet. Where it did? What did it? Oh, it said it failed. Come on, let me download it. It's failing. Okay, let me see. Since I can't do it. I don't know why they have to like irk me so bad. I worked super hard on it. Okay, let's scroll up and let me see what's going on. All right. Okay. CB says they were only going to have a conversation, yet Rocky brings a gun to the conversation and also pulls it out after being touched. And he's already kind of established the foundation as to why Rocky's walking around with it. Professionally dressed and wrinkled, he was. He kind of is. I have a little age on these eyes. Ooh, don't talk about me. I believe the part about him grabbing him. I do, and I think that the video backs it up. Like he snatched him up. He snatched him up. Wait a minute. Purple got mad at you? Chill, that's bro. I'm just saying he is a little wrinkled up there. The suit is ill fitting. I'm sorry. Yep, he said Rock. He said that they. Well, what he said was that he seen him with it in September, and that they went to go, I guess, down to Long Beach for something, and he's had it. So Ooh, y'all eat me up about that. I think he sounded rehearsed because he was actually prepped. If he's never testified, he's probably nervous. That's a good point, Dustin. That's a very, very good point. I agree about the fighting. I believe he's being honest. I think that it sounds like that part is coming from memory for sure. All right, it's a lot of people are believing that he's honest. So are we going to call the Bridge Gang or what? I feel like we need a name. We got emojis. we the Taylor Gang. Ash. Oh Lord. Court is coming back on, y'all. I'm gonna fix this emoji. And Karen, he about to bust out this suit. You talking about Takapina, Macho Man, the Incredible Hulk. He is definitely about to bust out.
All right, we're back in the record. Everyone is present. Back to Peter. Go ahead.
They told me you were at the point where you would sort of push Rocky home to leave, and I think that you said the bridge you started making your way away from Argyle. Point on the map up there with the pointer, which direction you really headed.
I believe he started coming down this way.
The Selma, right there. Okay. And then you made the left off the Selma Avenue, correct?
Yes.
Now, before that, let me ask you a quick question. At any point during this incident, one in the garage, did you display a knife?
No.
Turn around.
Turn around this way.
Okay. Were you carrying a knife at all?
No.
Now, by the way, in that video, you said you're off camera for a portion of it, but you see yourself on camera at some point, right?
Yes.
Okay. You know what, just, guys, play that one more time and just identify yourself when you see yourself in that little snippet.
All right there.
And where's your hand?
I believe I put my left hand on brother.
All right, so after the parking lot, you start walking. I'm sorry. You did that after. Yeah. So you start walking to Selma Avenue. There, correct?
Yes. We're walking down Argyle and we make the left on Selma.
Okay. And then, see where that little red thing, emoji of a gun is or something like that?
Yes, I see it.
That's Street Del Mar, then you make the left onto there, correct?
Yes.
After you left the parking lot, parking garage, I'm sorry, tell us what happens.
So after we leave the parking lot,
Garage.
Parking garage, it's really fast, but Relly and Rocky already, I guess, diffused the situation when they were grabbing onto each other. So that's already done. So I'm telling Rocky, like, yo, we out. Also telling Ill, we out. And also telling Rel,
You told him to do what?
we out. Like,
We're
out.
We are out.
We are out. Okay, I'm sorry. It's how I feel. All right, so I'm telling them, like, let's go. We are out. It's time for us to go. We can't conversate with our brother right now. Maybe we can conversate with him later. Let's go. So we all start turning the corner And as we turned in the corner, down the block and turned the corner, Relly is still following us.
And was he following you the entire time?
Yes.
Did he say anything that you heard?
Yes, he was yelling out obscenities
To who?
to all three of us.
Okay. How did he sound?
He sounded angry, you know? He sounded angry.
Did any of the three of you stop?
We stopped momentarily, all because we turned in the corner, we hearing him, and so Rocky is first once he turned the corner. So Rocky was already up. You feel me? So it's me and Ills in the back. Relly starts yelling, Ills, you're a crackhead. 12 of you live in the projects. He tries to belittle Rocky with the objects that he has, like, oh, I got this, I got the Cuban, I got the range. And we were all confused, like, you know, we friends, so it's like.
Is there a question, gentlemen?
Yes, there was.
Yes, calling for a narrative. Ask another question.
Okay. Well, I asked, what did he say? But okay, what did he say as you walking?
Yeah, he was, like I said, he said, yo, Ills, you're a crackhead. You told me you live in the projects. Yo, Rocky, I got this, I got these items, and I don't really need you.
Was his anger elevated at any point?
Yes. Not only is he a big dude, you know,
You've answered the question.
Most described the last.
Everything after yes.
How was his demeanor as you were walking away? Relatively.
Oh, he was, to me, it was out of control. You know, it was volatile. Volatile.
Did Rocky respond to him at all?
No, because I was telling Rocky, excuse my French, yo,
Most
Rocky.
described everything after no was non-responsive.
What was Rocky doing?
Rocky was turning the corner trying to leave.
And after you, all three of you turned the corner on Selma, did you turn the corner on to Still Mark right there, that little street?
Yes.
Okay. On the left there, there's a vacant lot, it's a parking lot, so, remember that?
Oh, right here, yes.
Okay. Did you personally say anything to Relly while he was following? By the way, just when withdrawn, let me ask another question. Did he follow you all the way around, including to Vista Del Mar?
Yes, he did.
Objection to the phrase follow.
Yes, he did follow us.
Okay. Did you say anything to Relly while he was following you?
I told him, excuse my French, to get the fuck out of here.
How did Relly's words and actions that you described him make you feel?
Being that this is a friend of mine, I felt
Objection
offended.
to relevance is that most described is most described means you're not going to The answer is stricken, the question is stricken. Ask one question.
Did you feel threatened by Relly?
Yes.
Indeed.
It is.
Okay, then, how did you feel by Relly's actions?
Objection to relevance overall. Over.
So at first I was surprised because this is a friend of mine. This is a friend that I've known the past 15, 20 years.
Objection, that's non-responsive. You can, everything after surprise, Your Honor, would be non-responsive. You can continue.
Thank you. But yeah, like I didn't see this occurring. I didn't understand why his energy was so like violent and things like that.
Objection again, it's non-responsive.
Were you scared?
I was threatened, yes.
Was it your impression, again, I'm asking you about your impression only, that Relly was about to get into a fight?
Objection, it's called for speculation. It's all
Sustained.
All right. By the way, were you, Chloe, in a position to have a physical confrontation or a fight?
No.
Why?
Well, to be honest, that year I worked out with Relly.
Objection, relevance, overall.
That year I worked out with Relly a few times, so I knew Relly was stronger than me. And I was
It's
also.
not responsive.
Were you in the position,
Yes, trigger.
okay, were you in the position personally yourself, physically?
No.
Why not?
Because of my inguinal hernia.
What happened when you reached the corner of Selma and East Selma?
So as you get to the corner, like, as I said, like trying to get Rocky up out there, I'm in the middle and Ills in the back. So Ills is trying to calm Relly down, you know, calm him down some way. And I guess it's not working. So I guess we walk a few more feet, and then I hear like fast steps. So I turn around and I see Rel hit Ills.
How many times did you see it there?
I seen him hit at least like twice.
And after Relly hit Bills, did Rocky win?
From what I recall, not when he first hit him, no.
Okay. After the second hit?
So after the second hit, Rel tried to hit me, and I moved, and then Relly hit Ills again. That's when Rocky shot down with the prop gun to scare Relly off. It didn't scare Relly off. Relly was still hitting Ills.
Did you hear a second shot?
Yes, but by then the car alarms and everything.
Did you see the second shot?
No.
After the second shot, and by the way, you said Relly came after you at one point?
Yes.
Say that for this, I'm sure your video. After the second shot, what did you do in regards to Rocky?
I went up to him and grabbed him to push him into the opposite direction to me. And I'm telling him, like, bro, let's go. We out here.
And did he go?
It took like a second to grab him because Rel was still beating up on Ills. He kind of wanted to like go help Ills, but I'm like,
Objection not to call for sustained about the story being answered. Sustained about what Rocky wanted to do.
Yeah, what Rocky wanted to do. Yes. So that answer again about what Rocky wanted to do. Got the question right back, please.
We'll save that for later. We'll save that. I'm going to show you a video later. After the second shot, what did you do in regards to Rocky?
Okay. Is that the last one?
No.
Okay.
D'Angelo went to him and grabbed him, pushed him to the opposite direction to leave, and I'm telling him, like, bro, let's go, get out of here. The next question is, and did he go? That was the last question.
Okay. That's the question.
Yes.
And did he go?
Yeah, he went.
Okay. And after he went, what did you do?
So after he went, and I seen him walking away from everything, I turned around I was like, all right, see, now I guess I gotta go handle the Rel situation. So I turned around to go walk. So as I turned around, I see like Relly hit Ills again, but he hit him again and he walked away. So then once I seen that, I seen Ills like get up and start walking my direction. So then I seen down the block, I couldn't see Rocky anymore. So then that's why I started running down the block to see who was there.
So you said you saw Relly hit Bills again. At this point, Rocky was already gone.
He was gone.
Now, did we show you the defense, show you the video that was turned over in regards to that night, November 6, 2020?
Yes.
Do you see Rocky in the video firing the sword pistol?
Kinda is grainy, but yes.
Okay. And when do you see that in relation to Relly punching Ills?
After the second time he attacked me.
And what did what was your understanding of the purpose of him firing that sword pistol?
Judge, it's a call for hearsay and speculation.
Hearsay. Rocky fired the sword, so did really stop?
No, you didn't.
All right, we're gonna play, Your Honor, that video, the video, I'm gonna play it through once, sir.
Which video is it?
This is the March video, one we discussed this morning.
All right, so this is
Defense.
additional defenses.
Foreplay.
Edward Allen.
Okay. Now, sir, what I'm gonna do, Mr. Phillips, is I'm gonna ask, I know it's strange. I'd like you to look at this video, we'll play it straight through the first time, okay?
Yes.
And then I'm gonna, after you watch it, I'm gonna ask you a question, and then I'm gonna go back to it again, okay? All right, it's not that long. Go ahead.
I hate to pause this for commentary, but so we finna have to explain why, if it was a fake gun, did he run?
Mr. Phillips, so does that video that you just saw fairly and accurately represent what you saw and what you heard on November 6, 2021 on this film?
Yes.
Okay, now that the tape again, this time I'd like you to, again, full time without stopping it, narrate what you're seeing, explain to the jury what you're seeing. So I think you have to sort of speak to that mic. So
Okay.
can you see it on your little thing?
Watch him run over to this side right there. He's gonna run.
Uh,
Hold on. He's going to run over here.
The last person that should be helping you with this, but.
He's gonna have to explain it on cross.
You know what to do. Just sort of look here, talk here. Unless the judge up here. Judge. That means the judge and the lawyer. Yeah. Sorry. We'll do this one, okay? It says no signal, check cable connection.
The only thing I ever do, Your Honor, is push the power button. I did. If it's saying no signal, then I think you gotta get the mark.
I got it.
Of course.
Stokes, no.
Just look at it on this one. I know it's not as big as that one, but just to narrate the video. We're not gonna stop and play it through all the way. Then we'll go back and stop. I want you to just narrate what you're seeing to the jury as it's playing in real time. And what you're hearing also, okay? Okay, let's go.
Okay, so the first person you can see at the corner, that's Rocky. Black figure. You see I got my red jacket. You still can see like the. You can still see my red jacket. You see it was in the back, right?
Can you point to the screen behind
Yeah.
you to the people that you're referring to?
All right. So this first person right there, that's Rocky. Like he's going. That's me behind him, and then that's the so we're already leaving. So then right there, as we're leaving the corner, Relly just swings on L's. So once he swings on L's a couple times, I hear steps. Then he tried to swing on me. He didn't hit me. Then he hit Ills. That's when I seen Rocky shoot at the ground to scare Rocky off. I'm sorry. I seen him shoot at the ground to scare Rocky off. And then I it stopped.
Okay. We're gonna play it again, make it easier, and we'll stop it as you're describing it, okay? So you can take your time and point. So, go ahead.
So this first person, that's Rocky.
Okay.
You see, he's already leaving.
Okay.
Then that's me.
Okay.
Then that's Ills.
And the white shirt?
That's Ills.
White shirt, yeah.
I think, yeah. It just looked white because maybe, I forgot what color the hoodie was, but it had like white fawn on his jacket.
So there's the four of you in that shot right there?
Yes, so that's me, Rocky, and Ills, and then that's Brother right there.
Okay. What do you see right there?
Right there, I see Brother attack Ills.
And is that before you see or hear Rocky fire a shot?
Correct.
Okay.
So then he's still attacking him.
Okay. And what did you just hear after he was attacking?
I heard the warning shot.
Okay. And where, can you see, go back a little bit, where Rocky fired that? You see where the video shows that he fired from here into the ground?
It was at the ground. I think it's at the ground. I can't really see it back there.
Okay. Now, so after that first shot, does Rudley let go of Bills?
No.
Okay, go ahead. Now, go back a little bit. You see yourself there in the red, correct?
Yes.
You start at some point. Now, there's the first shot, and they're still in that screen right there, right?
Yes.
Okay. At some point, you start running across the street. Why did you do that?
Because Ruggy was about to hit me. Like I heard him creeping up behind me trying to swing him.
Okay, you see that in the video?
Yeah. Instead of him hitting me, he hit Bills again.
Okay, now
Don't
let's.
just like the last one is non-responsive. What's the question? Yeah.
You see that in the video.
Okay.
Yeah, so after he hit Ills a couple times, he tries to hit me, right? So then I juke and I head across the street, and that's when he hit Ills again.
Okay, hold on. Let's play that part. We'll try to stop. Okay, go back, guys. Now look at you compared to Rudley. You're where is your point? We did a little point there.
So right here and right here. So we right next to each other.
Okay. And is your testimony that he started coming after you?
Yes.
And then that
I juke and I run across the street.
and that person, where's Rudley at this point?
Rudley is right here, still on top of Ills.
Okay. And you see in this frame, in this couple seconds, Rudley's arm cop, yeah, this is after the first shot, correct?
Yes.
You see Rudley's arm cocking back. What do you see, Rudley, if anything?
So after here, I see Rudley just swinging on Ills. So at this point, he's just throwing haymakers.
Go ahead, Joe.
So right, he just swinging, he's just throwing haymakers. You see his arm swinging.
No, stop it. At this point, both shots are already fired from the property.
Yes.
Okay. You have the car alarm going off?
Yes.
Despite the fact that both shots from the property were already fired, and Rocky was not next to the two of them anymore. What is Rudley doing right there?
Rudley
Yes,
is,
that's a leading question, and it's argumentative as well.
Rudley is still, he's still attacking Ills.
But
But you see that he knocked Ills down on the flip.
okay, now stop it. Is that you walking away after Rocky ran?
Yes, that's me right here.
And what did you say you did before you left the location?
I went to turn back to see it, like, if they were still fighting. So at that point, I say, all right, Rocky's out the way. I'll go handle the situation with Rocky, you know, or at least help Ills. So as I turn around, I see him hit Ills one more time and then leave.
Okay, show us where that is in the video. Go ahead, sorry, that's you.
Yes, we right here.
Where's Riley?
Riley and Hills about back here.
That's Hills, and you see Riley?
Yeah, right there. He walked over there to hit Hills again, and then I guess.
Your Honor, the stated objection, do not make a speaking objection, just, as soon as it's back on it, sustain.
Motion to strike the last part of the answer.
Let's rewind that for a second. A little bit, that's, okay, we want to do a little bit more. Now, right here, let's freeze it right there. Describe what you see on the screen, is that you in the red?
Please take for the record where we are on the,
Sure.
because it doesn't. 29 looks like.
It's 29 seconds. Okay, go ahead, Mr. Phillips, tell us where you are.
That's me right here. That's Rocky Lee.
It indicates the record's clear. He's pointed to himself, we're looking at the screen, there are 4 people on the screen. He's indicated he is the second from the right. He's indicated that the defendant is the first from the right. Is that?
Yes, yes.
Okay, so you said now, what happens if that you look back?
I look back, I see what was going on with Ills and Relly.
And what did you see?
I see Relly hit Ills again.
Okay, show us where. And where, by the way, stop. Where is Relly in this frame?
I think the big figure right here, but it's Relly right here.
The witness is saying he believes that Relly would be the second person from the left, and that Ills would then be the first person from the left. Is that correct, Your Honor?
Yes, yes. Because I believe he walked back onto Ills and then hit him again before he went up there. All right.
Okay, let's see it play.
See, he walks back.
No, there's no question pending.
What did you just see?
Hands in that.
Mr. Tackleton is asking you a question.
So I seen him walk back and hit him again.
And then after he hit him, where did he go? Relly goes.
He walked up. Is that our guy?
That's Argyle.
Yeah. So he walked back to our guy.
No, that's Selma, I'm sorry. Oh, it doesn't matter, hold on. Selma.
Is Selma? Okay, we walk back up Selma.
Now, we can turn first. Why did you tell Rocky to leave?
Because we were in in LA. This is during COVID. You know, I'm not too sure what else is going on, but the car alarms are going on. It's bringing a lot of attention to our surrounding area. So I was like, yo, bro, like, just get out of here. You know, he said Rocky's very recognizable. It's just getting about
Did you have to convince him to leave?
Only had to convince him to leave because he wanted to make sure Ills was okay.
Jackson, false speculation.
Staying about what Rocky believes.
Did you have to convince him to leave?
No,
Did you physically push him?
I pushed him, yes.
Where did he, you know which direction he left in? I mean, obviously from the video.
Yeah.
Down, Mr. Belmar.
Yes. So he started going in the basically.
You've answered the word, you've answered yes. That's enough.
And then did you run in the same direction?
Yes.
Did you see Ills soon after the incident?
Yes.
Okay. What did he look like?
You can tell he got into a fight. Yeah, blood on his leg.
In this fight that you tried to hustle with Relly and Ills,
Yes.
did you see Ills punching back to Relly?
No.
Okay. And Was Relly controlling that fight?
Honestly, Relly was like fake bragging, it was on the floor. Like, Relly, he's a big dude, he's way bigger than that.
Objection non-responsive. Motion to strike. Your Honor, to the witness, he's mentioned 8 times that the victim is a big dude, but there's no question pending. Can the court advise the witness to only answer what he's asked?
No, Your Honor. I asked it. I'm not asking questions.
Only answer questions.
No problem.
Don't volunteer.
Was Relly, when you say ragging, what does that mean? Relly was ragging.
He was getting invested, he was being, it was up.
How tall are you, by the way?
I'm about 5'10", 5'11".
Okay. How much do you weigh?
Now I weigh 180, but during the event, I was like 160.
Who was the aggressor on both those instances, the parking garage and the Stelmar?
Relly.
No, sir. Just a couple more things, Mr. Phillips. Are you on Rocky's payroll?
No.
Are you financially dependent on Rocky?
No.
You make any money from Rocky?
No.
Now, obviously, you love him like a brother, right?
Yes.
Before 2 weeks ago, now we're in January 2025, we're in February 2020. We're in February, right? Now?
That's
a rumor. That's a rumor. It could be June for all I know. But 2 weeks ago was January 2025. Okay? You were asked if in January 2025, after the trial had started, if you wanted to speak to the police or the district attorney. Remember being asked that?
Yes.
And you said?
No.
Before 2 weeks ago, in 2025, this incident happened in November 6, 2021.
Yes.
In those years, 2021, 2022, 2023, 2024, did anyone from the police or district attorney try to speak to you ever once?
No, that's gonna call for speculation in terms of what we tried to do.
Did you ever hear from anyone from the police or district attorney's office until 2 weeks ago?
The witness answered the question before it was asked, so I think probably we should ask again.
Did you ever hear from them? I'll ask it again. Did you ever hear from anyone prior to 2 weeks ago from the district attorney's office or the police department asking to interview you?
No.
How many times did, when we meet a collective defense team, how many times did we meet, sir?
I believe only twice.
Okay, when was the first time?
It was August 2024.
Okay. And the second time?
It was last night.
And other than that, have we discussed your testimony?
No.
Ron, I have no further questions,
Do
Mr.
you,
Phillips.
do you want to get started now?
Yeah, I can get started. Kevin? do you consider yourself, what do you want me to call you? You want me to call you
Mr. Phillips.
Mr. Phillips? Mr. Phillips, do you know what the word unbiased means?
Yes.
Do you consider yourself, if you're coming in here, to be an unbiased witness?
Yes.
So, is it your position that if the defendant committed these crimes, and it's proved beyond reasonable doubt, that you want to see him convicted?
I was there. I know the defendant didn't commit any
Most
crimes.
described as non-responsive.
That's not the question he asked. He asked you a yes or no question. Listen to the question again and answer the question.
Can you rephrase the question?
Sure. So what I'm asking you is, I want you to assume for a moment
Yes.
that the evidence in the case demonstrates that the defendant is guilty beyond a reasonable doubt. If that is the case, isn't it true that you don't want to convict him?
Overruled.
Well, I can't really answer a hypothetical question.
When you say you can't answer that type of question, you indicated he's like a brother to you, correct?
Yes.
He gave you your start, correct?
He didn't give me my start, but yes, he is a brother to me.
Well, you indicated he got you out of a bad record label deal, correct?
I never said it was a bad record label deal. I just say he helped me get out my contract.
Was the contract you wanted to get out of?
Only because I felt as though it was.
Motion to strike, it's non-responsive.
You want to get out of that contract?
Yes.
And the defendant, who you would agree is a very powerful individual within the industry, helped you get out of it, correct?
Objection.
Overruled.
I honestly read a contract book about the music
Motion to
business.
strike is non-responsive.
You're not answering this question.
Let me take it one at a time. Do you agree that the defendant is a very powerful individual within the music industry?
Yes.
Do you agree that he was a powerful individual within the music industry even back in 2021?
Yes.
Do you agree that you have much less power and influence in the music industry?
Yes.
Would you agree that if the defendant wanted to tomorrow, that he has enough power to pretty much end your career if he wanted to? What's
the ground?
Argument. It's all for speculation.
Does, given what you've said about the defendant's position of power, if he wanted to, do you believe that he has the ability and power to end your career tomorrow?
Objection, or it's the same question.
Well, it is, but it goes to what Mr. Phillips believes, and I think that is relevant to,
No,
I think it's a fair question.
No, I don't believe that.
So as you sit here today, is it your belief, I want you to assume for a moment that the defendant doesn't like your testimony. He decides, you know what, I don't think Mr. Phillips did well on the stand. Wouldn't you agree that if he wanted to, not saying he would, he could make a couple of phone calls, and all of a sudden, you don't have the career that you have right now, correct?
As phrased, sustained.
Under what ground, John, was it? There's no ground.
Or cause for as phrased, it calls for speculation.
I'm asking you what he believes, Your Honor, goes to his.
No, your last question did not mention the word believe.
All right, do you believe, Mr. Phillips, that as you sit here today, that if the defendant was unhappy with your testimony, that he has the ability and the power to significantly affect your career going forward?
To be able to accurately answer that question, I would need to apply more information.
What information would you need to apply?
Because me myself, if that's a hypothetical question, right? But I'm an artist and I could go buy another artist name tomorrow and start over.
Well, you would agree that the defendant, as well as his significant other, Rihanna, are very powerful people within your industry, correct?
Yes.
And wouldn't you agree that if they decide they wanted to blackball you, you're blackballed tomorrow, correct?
Well, no.
No?
No.
So it's your testimony that no matter what you said today, that even if the defendant and his significant other, Rihanna, were upset with you, they would have no ability to impact your career going forward?
I know because I believe, as I told you before, I'm an artist. I could start a new way of creating tomorrow. I could be a painter. I could go sew and be a designer and still be able to live my life.
All right, he's answered the question. Go on to another topic.
I want to talk for a moment about your statements in court today.
Yes.
Want to approach, Your Honor?
You don't have to.
I want you to read to yourself the middle of this page. There are 12 bullet points. I want you to read what we have, starting with the following, and right where it says himself. Read that to yourself. Let me know when you're done.
So from one, right here.
No, actually I want you to read where it says the following. Yeah, for one, I'm sorry. Didn't see that. That's one.
Do I have to say my address out loud?
No. To yourself.
Oh.
You're not reading this out loud. That's why I brought it to you.
All right, Taylor gang members, I dropped y'all a new emoji. Too much. If you feel like something is too much, drop that too much emoji in the chat.
That has been represented. Sustained. Mr. Phillips, does what you just read, does that completely encompass everything that you said to the defense during your one interview with them?
Objection, Your Honor.
Sustained. There's no grounds.
There's grounds. It's misleading because it's not a sworn statement. It's not a written statement. It's.
That's not a proper objection.
I this
All right. That's one. Both of you.
You're on the grounds.
All right. Both of you. 77.5. State the grounds. Sustained. The objection is sustained.
During your interview that you had with the defense, did you mention the 3 incidents involving the prop gun that you testified to today?
I believe so.
When you say you believe so, do you know that you mentioned them or not?
Yes.
Did you see when you reviewed the summary, the explanation of what you said, did you see any mention of those incidents?
Your Honor, objection. Let's say it's misleading. He's asking direct questions. So I don't want to speak. I don't know what to do. Just the same objections before. Reading from
On that ground.
Do you understand my question?
Can you rephrase it?
So I've just shown you what's been represented as your statement in this case, and I'm asking you, does it in anywhere mention the 3 incidents you just testified to about the defendant previously having a prop gun?
But it's not a need. This is.
I'm objecting. It's not.
Read back.
I'm objecting because.
No, I understand. Read back. I might miss something in the question.
So I just shown you what's been represented as your statement in this case. And I'm asking you, does it anywhere mention the 3 incidents you just testified to?
It's a summary of your statement.
So Your Honor, just a summary, I'm asking you, does it mention anything about those statements? Those incidents? Does it mention anything about the 3 incidents you just testified to in 2018?
On this paperwork, I never seen this paperwork and I never made a statement, so I'm not too sure where this came from, but I advised about the situation that I've known before about the property.
So what I'm asking you is, when you were interviewed by the defense in this case, did you tell them about the 3 incidents in 2018?
Yes, I had to.
And how sure are you that you told them?
think I'm pretty sure.
Did you tell them about the situation that you testified to involving ASAP Josh?
Can you rephrase that?
Did you tell the defense during your interview with them about the situation with ASAP Josh that you testified to on direct?
The situation as far as him passing away?
As far as any mention of ASAP Josh and the issue with Relly and Rocky, did you mention that to the defense?
I probably didn't. Because I had no.
Motion to strike, everything after no.
I wasn't.
You didn't say no. Objection. You didn't say no.
I wasn't involved.
Stop. I was making notes myself. Read the question.
Question, as far as the mention of ASAP Josh and the issue with Relly and Rocky, did you mention that to the defense? Answer, I probably didn't. Because I had no.
So is the answer yes, no, I'm not sure?
I'm not sure.
Did you mention during your interview with the defense anything about you yourself having used prop guns in videos?
I'm not sure.
How long was your interview that you had with the defense?
Maybe an hour.
Do you remember when it was?
It was August 2024 in New York.
So you're saying you had no interview with any member of the defense team in this case before, when did you say, what day?
August 2024.
So you were never interviewed by any of them until almost 3 years after the incident?
Correct.
And when they were interviewing you, who was there?
It was Joe, Eleanor, and Chad.
And were they recording it?
Yeah.
What was the answer?
No.
Did they write notes that you saw?
No notes.
Did they ever talk to you afterward and say, hey, listen, here is your statement. Is it accurate?
Not that I recall. No.
Did they ever even show you what they were representing your statement was?
No.
You would agree that even as we speak now, that the defendant, who you call a brother, that would be a relationship that is much closer than someone who's a business associate, right?
Yes.
It would be much closer than even someone that you would call a close friend, correct?
Yes.
Can you have a closer relationship in your mind than with someone that you refer to as your brother?
Yes, you're actually like your blood brother, that your parents' birth.
But that would be about it, right?
Yeah.
So in terms of friends in the world, this is about as close a friend with a defendant as you have, right?
No.
How many individuals in your life are you as close to who are non-family members as the defendant?
Everybody in the ASAP collective.
So you are equally close to everybody in the ASAP collective?
I show no favoritism, yes.
Well, didn't you testify on direct examination that, as an example, once you started traveling with the defendant as his hype man, that you didn't have really, I think your words were time for Relly anymore, correct?
It was time to hang out with Relly. We still maintained a verbal communication.
So is your testimony that you are as close to all the other ASAPs as you are to the defendant?
Yes, that's a fact.
And is that true to this day?
Yes.
Do you travel with any of the other ASAPs on tour?
Yes, I do.
Did any of their ASAPs, have they made it so that you were able to be their hype man?
Times, yes.
So is ASAP Tom's, is he as?
No, I said at times, yes.
Is he as big as?
No, at times.
He's saying at times.
Oh, at times, I'm sorry. So when you're saying at times, you would agree that the defendant, he's the only person that you traveled across the world with, correct? Of the ASAPs, where it's on his dime.
That is not true.
In terms of your work right now, in terms of what you're doing, you said you don't have a business relationship with him, but how often do you see and talk to him?
So since he had his kid, probably like once or twice a month, and he's always traveling, so I don't get to see him that much.
Do you text with them still frequently?
Not really. Last text I sent was like on Yams Day.
You would call yourself a performer, is that correct?
Yes.
Do you do any acting as well?
No.
But you mentioned before that part of your job that you indicate as a hype man is you want to get the crowd going, is that right?
Well, for anybody that's a hype man, that's a part of the job description.
Right, so what that kind of means is that means looking at your audience and trying to figure out how you can get them excited or motivated, is that right?
Well, I wouldn't say motivated, and they're already excited because they have the show. It's just more or less have them.
Don't sit so close to the mic.
Okay. It's more or less have them feel like they're a part of the show.
And in saying that they're a part of the show,
yes,
you have to sit there and you have to kind of figure out, as a performer, hey, I'm up here, and how do I connect with my audience, whoever that is, right?
In a sense, yes.
As you sit here today, are you doing the same thing with the jury?
No.
You were asked questions by Mr. Tapafina on direct examination. Are you aware that approximately 8 or 9 different times when you were not asked, you mentioned gratuitously that Relly was either a large man or very muscled or big? Are you aware that you did that? What was he
Sustained. Argumentative, sustained.
Why did you, Mr. Phillips, repeatedly mention that Relly was a large muscular man when you weren't asked?
Objection, are you? Same objection.
Well, the word repeatedly is argumentative.
Are you aware, Mr. Phillips, that during your direct examination, that you mentioned several times that Relly was a larger muscular man?
Yes.
Are you aware that when you mentioned those comments, those were not in response to questions that called for that answer?
Objection, argument.
I was basically just giving a description of Relly. That was all I was doing.
When you were asked those questions, Mr. Phillips, would you agree that when you were giving that answer, you weren't being asked to give a description of Relly, you just added it? Would you agree?
I was adding a fact.
I'm sorry?
I was adding a fact.
So you were adding a fact that you wanted to make sure the jury knew, but it wasn't a question that you were asked. Is that correct?
Objection, argument.
Sustained. Why, if you were not asked a direct question to describe what size Relly was, were you telling the jury he's a large man, he's muscular? Why did you do that?
Again, Lawrence.
Overruled.
Basically, I was describing a friend of mine that I used to work out with, and I was giving that detail just to let y'all know why I couldn't fight him. You know what I'm saying? Why I couldn't pull him back at anything, because he's stronger than me.
Did you end up providing that information several points during your direct examination when you weren't being asked anything about why you didn't fight?
Well, that's an argument.
He hasn't finished the question.
I thought you did, sorry.
Did you finish the question?
I did.
Argument, objection.
All right. Read the question back.
Hopefully Takapina remembers.
Writing that information several points during your direct examination when you weren't being asked anything about why you didn't fight.
Can you rephrase the question?
Oh, she just, okay.
No, so I could answer you.
I'll just have the court reporter read it back so that we don't have any issues.
Okay. Kathy's gonna read the question.
Okay, no problem.
Question, did you despite the providing that information at several points during your direct examination, you weren't being asked anything about why you didn't fight.
I stated earlier when I got on here that I had an inguinal hernia surgery and I couldn't fight.
Motion to strike non-responsive.
So the question is really confusing. Let's take a break now, folks. Please be out.
The judge said he's sick of it. He said he tired of Louis' question because Louis' question is confusing everybody right now. Okay, Louis wants to know why was 12V offering the information that really was so much bigger than Rocky? Well, obviously, one, he was just trying to describe the situation. He's giving it from his perspective. He wants everybody, and yes, the jury, to know that really is a bigger person. Thus, the need for why else would Rocky have the desire and need to pull the gun? Why else would I feel threatened or run away from him or try to avoid him while he's angry like that, knowing he's a bigger guy than me? I've worked out with him and I can't handle him. And honestly, y'all, I thought 12 was going to fold. I wasn't too sure on how he was going to hold up on the stand. I wasn't sure about that. So very, very interesting testimony from 12V. Thus far, I mean, Lewin is trying to break his credibility. He wants him to look biased. He wants him to look one-sided. He's trying to put in front of the jury that he's got this relationship with Rocky that he doesn't have with everybody else. And if he doesn't do or testify the way that Rocky or Rihanna, because he name dropping, the way Rocky or Rihanna wants him to, that he would end up in a bad situation with his career. But really, Rocky, oh my God, y'all. 12 is coming back with some very interesting answers.
It's a summary, but what the court said was, quote, if there is one area that they cover that is not in this summary, then they're going to contact.
What area?
Well, Your Honor, so
What area are you talking about?
there is nothing about any prior incidents involving the defendant being threatened. There is.
All right, hold on.
Okay.
It says, according to the summary, Rocky carried a starter pistol for security measures, which he was known to do after being the victim of violence and home invasions. I believe that is sufficient. Your Honor, I believe that is sufficient notice of what he's going to say. Do you want to say anything else?
Yeah, you're wrong. I need to say something else, Your Honor.
All right, say whatever you want to say.
So, Your Honor, there is no incident that is related here. So there is no way, as a competent trial lawyer, when they give a generality and they simply say, and that's all we get, he was a victim of violence and home invasion, then the court believes that that is sufficient for their discovery obligation for him to now talk about specific incidents, which, by the way, he said he related to them. I'll be clear. They were given that information before.
Mr. Gordon, you better tone it down some. Don't yell at me.
I'm not going to.
Oh, yes, you are. Tone it down.
They were given this information clearly during the interview they had with him. They did not turn it over. There is no way. How am I supposed to be able to cross-examine this witness when I'm ambushed with 3 incidents that I've never heard of?
All right, let me hear from.
Your Honor, again, this is not a complete presentation. It's not a.
His position is, since it mentions 3 incidents, 3 specific incidents, but it's not in your summary.
Your Honor, right here, Rocky carried a starter pistol, prop security measures, which he was known to do after being the victim of violence and home invasions. That's what he's going to do.
His complaint is that it's not set forth the specific incidents.
It's a summary. That's what we stated. That's how we started this. And we talked about home invasions, which is what he spoke to.
Just so reasonable minds can differ. I believe it's sufficient.
Your Honor,
If there was no mention of that, I would agree. In the summary, I would agree with you.
Your Honor, again, they have 12 bullet points here. Nothing specific at all. Remember, Your Honor, they're not allowed to give me a quote summary. That's not what the code requires. The code requires them to give me what he said. So what they've done is they basically gave a summary where they left out any detail whatsoever. The court's aware of it. The court said.
I have.
So, Your Honor, how exactly am
I supposed to cross-examine the witness when they are coming up with specific information that I'm supposed to have been given 30 days before trial, and I'm hearing about it as he's testifying, and I've raised the issue at least 10 different times. Your Honor, I predicted, I told the court on the record repeatedly, we have 12 bullet points for an hour's worth of interview. They're saying they didn't record it. They're saying that they didn't take any notes. They're saying that they didn't write anything down. That absolutely flies in the face of reality. I've done this job 30 years, you've done it even longer. There is no possible way that the defense did not cover these areas that they are asking them about in advance. The fact that they're not providing them, Your Honor, and that's just some of them. So now what I have to do, this also goes to, I can give the court 5 other examples from his direct evidence, his direct testimony. But now what I have to do, Your Honor, is I have to basically go through and I have to now address to the witness, well, listen, you testified to so-and-so. Did you previously relate that information? He has now said that he did. He said, I told him that with respect to the 3 incidents. We don't have it. Your Honor, under 1054.3, that is as clear a violation as you can have. The court's position is going to be, well, they told you that there was an incident that he did it for security measures for violence and home invasion. Imagine if the discovery on our end, this prosecution was, hey, we're not going to tell you anything about the case, but someone got killed. Never get you facts, but someone was shot. Your Honor, would we be taking the woodshed, which would be appropriate? So my problem is that
You would be taken to the woodshed if there was not a police report and that was not conveyed to the defense.
and we don't have any report, we don't have any tape, and it wasn't conveyed to us. So the problem, Your Honor, is I'm doing the best I can
Right.
to try and cross it, but then the court is also.
I've heard enough.
All right.
No, I don't need anything from you either. In my belief, this certainly could be more expansive, but I think it is sufficient. As far as you cross-examining, I'm not aware of anybody who can cross-examine better than you. I'm sure you can figure out a way to cross-examine him based on what is contained in this summary. We're off the record.
Yo, drop those gavels in the chat because Judge Arnold is not having it today. He is not for the squabbling. He is not for the back and forth. He said, I said what I said, and that's what I said. So I need to know, y'all, how many times, Cindy done threw the book at him. Cindy threw the book out there at him. How many times did y'all count a sanction? How many sanctions did y'all count? We also got the new coins emoji. Somebody, I can't remember who exactly was, requested the coins emoji. So we got some coins out there. I need y'all to throw coins to tell me how many sanctions did y'all count? The walk-off 8. He's sick of it. Yay, say 50 left. Queen Ash Bash says 1 each. Saya, let me tell you, girl. So basically, the state was arguing that they couldn't effectively cross-examine 12V because they had no idea about the incidents in 2018, which prompted Rocky to start carrying a starter pistol. So if you remember in the beginning of his testimony, 12V alleges that, they were jumped in the club and he was stabbed, but both of them were stabbed. He and A$AP Rocky was stabbed. And then after that, they ended up going to his house, and a few times at his house, maybe his house was robbed or something, and that prompted Rocky to start carrying a starter pistol or a prop gun. And the way that the defense gave that over to the state They basically just said he started carrying a prop gun for security measures without saying specifically what happened. And so he feels like he's not able to effectively cross because this is basically his first time hearing exactly what those security measures were. And so the judge is like, I don't care nothing about that. You were told it was some security measures. You can cross-examine. I ain't trying to hear it. And so, we just feel like he laying down the law. And I mean, he hitting that gavel going both ways. The gavel was going both ways, y'all. So we ended up dropping some gavels down there in the chat. If you don't know what's happening, y'all. So I figured out how to get us our own emojis created for the Taylor Gang members so that we have something exclusive for our members. So I spent some time. I was even making some while we were watching this feed. And so we've got a few different emojis that you can choose from. So if you are in our chat and you don't have access, all you got to do is become a member, and you can jump on the Taylor Umbridge channel's stickers. So we are having a good time today. But I just feel like 12E is not going the way the state wants him to. He's trying really, really hard, and 12E is giving absolute great answers when he's getting stuck in these situations. So yes, Wolverine, Lewin needed to do his own homework. And Sonya, Lewin started yelling at Judge Arnold, and Judge Arnold told him to tone it down. He said, pipe down. Do not yell. Tay will be my lawyer. I have to get in, y'all. I got to get in first. Yes, today is great. Today is a great day. I didn't know how fun it was going to be. Like, I was a little nervous about it, Kim, but I'm actually excited that the emojis are working out pretty good. So I'm going to try to see what other little perks we can add to our memberships. But what we know is that I think, and I'm not going to keep saying the same thing over and over again. Yes, girl. I'm not gonna keep saying the same thing over and over again. So I think I kind of covered what he went over on Cross and on Drake and on Cross. They're just trying to kill his credibility. Just show that he has a close relationship with Rocky, and him trying to solicit that Rihanna and Rocky are powerful people to end his career. The way he spent that, I say, good God Almighty! I was looking for a way. I was in the chat answering his questions for him because I was worried about him. But that man said, "Look, I'm a Renaissance man." He said, if this career ends today, I can start a new one tomorrow. I'm an artist. I'm a designer. I'm a model. I can start a new career tomorrow. So no, can't nobody end me. He was so upset that he wanted to explore that so bad, and the judge told him, "Keep it moving, son." He told him, "You cannot continue down on this line of questioning. You need to go find something else to talk about. Let's get to the meat and potatoes." So right now we are on a lunch break. And guess what, y'all? We can stream one day today, but we are definitely taking a break. Okay? We're taking a break. Y'all know today is Sandra Bland's birthday. Happy heavenly birthday, Sandra Bland. I did not know that, Ash. Thank you for sharing that with us. Yes, he definitely held his own lately, where he was laying. Queen says he was laying it down. He absolutely was. I think now I'm interested in hearing where Lewin is going to decide to go over lunch. He's got a little bit of time to think about what was said on direct examination. And so I'm curious on how he's going to come back and what he's going to go after and attack. He's still got some meat on the bones, right? Because I think he's going to go hard on the video and the narrative that was provided by the video. So that's going to be super, super interesting. And then before we ended, he was kind of going in on, or did he move off of it? Before we ended, I want to say he was going in on why 12E kept explaining to the jury how big Rocky really was in comparison to everybody else. So yes. As the state, they run a search Rocky being victim. Rewrite that for me, so did he go? I don't think I'm following this. Oh, as the state, they can run a search of Rocky being a victim. Exactly. You can see how many times the police has been to his house, what for, what type of calls were made. If they were, you're right. You're absolutely right. Oh yeah, so if you click the smiley face, you should be able to see the emojis. You can see them. Awesome, awesome, awesome. Everybody is wishing Miss Sandra Blinn a happy heavenly birthday. So yeah, y'all. All right, so I'm just gonna tell y'all right now, I'm gonna end the stream because I do want to cut our. I don't know if I can cut the YSL stuff out of it. Until we come back. They're coming back at 1:30. So that is. Yep, Ash. If you become a member, you can start using the member emojis. Our memberships over here are only $2.99. I don't think I have 2 tiers. I don't have like a bunch of different tiers because I'm still learning. So as I learn, it may change, but I always keep my $2.99 tier because I'm trying to pay somebody $1,850, $3,500 a month. Like life already hard. Life is already hard. But yeah, so let me drop the link too. Let me drop the link. I don't know if any of the mods have the link. If any of y'all got the I don't know if any of y'all have the invite viewers to join your channel. She said, I'm not going over our cousin's house. You're not gonna have to go over our cousin's house today, Sonia. I'm gonna come back on. I'm gonna come back live. I want to wash my hair before the kids get here. To be honest. I'm tired of this ponytail. I'm tired of the gel in my hair. I want to wash my hair real quick. So that's why I'm gonna end on lunch. We're gonna take us a lunch break. We're gonna lunch break with the court today. That's all. That's all, Sonia. That's all. I'm sorry. Ah, LaRon. Ash, you too. Kim too. We're coming back. I'm coming back. I'm coming back live. In just an hour. In about an hour. So I will see y'all back in 1 hour. We're gonna pick up our stream so you can keep watching here on the with the Taylor Umbridge game. So yeah, I mean, I'm about to go wash my hair. So I think it's kind of weird to leave y'all just on hold until I come back because I'm gonna be gone for an hour. Like I'm gonna go wash my hair. So I think that it'll be too weird to leave y'all on hold. And I don't have nobody to, you know what I'm saying? I don't have a co-host to commentate for y'all. The state had the opportunity to research whether or not Rocky was a victim. So the defense didn't have to give him that information. Absolutely, I agree with that. So did he go? I agree with that. D-Wood, you're gonna have to start giving us the workout plan because you built. We trying to figure out how to get our bodies like that. Not that weird, but go ahead. We have each other. We'll be back. I'll be back though. So let me tell y'all, all 142 of y'all that are watching from Twitter, all 47 of y'all that are watching right here from YouTube, I will be back after the lunch break. So take an hour, go decompress, think about it, and I will see y'all in a minute. Cindy. Cindy is hilarious, yeah. All right, I'll be back.